Good morning, everyone. We're going to get underway. Thank you for being here in person and online. We have about 600 or so people joining us virtually, which is fantastic. And we're truly grateful for those who are here with us in person and joining us virtually for today's workshop on Part 10 of the Child, Youth, and Family Services Act. I'm Mike Maddock, Assistant Commissioner, Strategic Initiatives, External Relations at the IPC, and I'll be up and down today helping run the proceedings. I'd like to begin by acknowledging the land that is located in Toronto. There are trees standing in the water. First Nations peoples, including the Anishinaabe, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaty signed with multiple Mississaugas and Chippewa bands. I also want to acknowledge those that are joining us virtually from traditional territories and communities across the province today. We offer this land acknowledgement to recognize, respect, and honor these territories, its original occupants, their ancestors, and the historic connection they have with the land. So today's session is on Part 10 of the CYFSA. It is the second in the IPC's Insights to Impact series. The next one is on April 28th. It's our final one. It'll be here at Mars and online, and we'll focus on the Personal Health Information Protection Act, or PHIPA. If you or your colleagues are interested, you could sign up online on our website. I'm going to go over a little bit of housekeeping items today. What we're doing, you'll see throughout the day, we have a few interactive surveys, which we'll throw up on the screen. I encourage you to participate using the QR codes at your table. I want to ensure that the polls are 100% anonymous, but they really do help our discussions, kind of, touching base with you throughout the day, giving us a sense what's top of mind for you, so our presenters and panelists can maybe speak to those issues. We're also using Slido for the Q&A sessions today. We've built in Q&A time into each and every session. I really do want to hear from you and have a dialogue throughout the day, so I encourage you to use Slido. We'll also, I believe, have a roving mic. Just put up your hand and we'll come to you as well. We're going to start the morning with a greeting and welcome from Danette Rastoul, Elder in Residence at the Association of Native Child and Family Services Agencies of Ontario, or ANAFCIO. Then we'll have Commissioner Cossine share her opening remarks, followed by a suite of sessions from the IPC team talking about what's new in the CYFSA, key tribunal decisions, what's happening in the courts, new policy guidance that's coming out, as well as supportive resources. In the afternoon, I'm really excited. We'll hear from a panel of professionals from the CYFSA sector. The panel will be moderated by Solomon Owu, who many of you may know, Chief Executive Officer at the Ontario Association of Children's Aid Societies, joined by Michael Miller, Executive Director at ANAFCIO, Jody Potts, Supervisor of Service Relations and Privacy Program at the Durham Children's Aid Society, Alison Moon-Simoen, Director of Legal Services and Senior Counsel at York Region Children's Aid Society, and Max Behrens, Youth Advocacy Leader at the Children Family Services Grand Erie, and Youth Can Provincial Youth Advisory Committee. Thanks for being here, everybody. We really appreciate your time and engagement with us. We do expect an engaging discussion from the panel, bringing together such a great group and grounded in real-world experience, focusing on the challenges they face, as well as practical solutions, and expect it to be a great dialogue. Following the panel, we'll end the day with a joint Q&A session with the panelists, the commissioner, myself, and my colleague, Stefan Luciu. And then we'll wrap the day with a closing reflections and prayer from Danette. I do want to highlight that as we go throughout the day, some of the topics we're going to touch on may be potentially sensitive, distressing, or bring back some memories for folks that are not pleasant. I encourage everyone to take care while engaging, and feel free to pause or step away at any time if it feels overwhelming. Ultimately, the well-being of our audience members, the people online, and our participants is the utmost importance to us. So with that, it's my pleasure to introduce Danette, Elder in Residence at ANAFCIO. to share a greeting and welcome with us, and encourage Danette to come up and join us. Big round of applause for Danette, please.
Thank you. Good morning, everyone. Minokishep, Kinawea, that's how I say good morning in my language, in my Ojibwe language. I just wanted to say, as we approach the golden age, we get the privilege of being helped up the stairs. We get that really awesome gentleman service. Thank you, Michael. So my name is Danette Rasool. I'm the elder in residence for Anasio. I've been there about 6 years now. I've worked in the field at many different capacities for about 40 years, from frontline, band rep, senior management, community development. So I've had such a wealth of experience and teachings along the way. My people have been the greatest teachers in my life, and I often think about some of these things that I've had the privilege of experiencing are things that I could have never learned from a textbook. As we all know, anything you read sounds good most of the time, but it's the implementation process that causes a lot of challenges along the way. So I'm really privileged to have this opportunity to work with Anasio, because along with that, I get to work with the elders of Ontario that represent each of the Indigenous agencies. So along with their collaboration, their direction, and their guidance, it gives me the opportunity to extend some of those things to you today. So I feel very privileged to have such beautiful mentors, and I often say that they've been here on this land a lot longer than you and I have. They have witnessed, they have experienced so much more than we have ever experienced, witnessed, along the way. I hold them in the highest regard because they're still standing beside us to say, don't give up, keep on working. The work that we do in Child and Family Services is extremely a lot of heavy lifting. And I say that because I've worked for my own communities, my very own community and many First Nations. And when you share a small geographic land base where everybody's related, it makes it really challenging to be able to instigate, motivate, and inspire change. Because we acknowledge the necessary healing that needs to take place, because we carry the residue of our ancestors. For hundreds and hundreds of years, our grandparents have been in residential schools. They have experienced the 50s and 60s scoops. Even our elders have experienced that sit on the Elders Advisory Council. So when they share from experience, lived experience. And so that's why I say it's such a privilege to be able to carry that voice of experience and to be able to inspire and motivate change. Because one of the things that I love to say and acknowledge is we are in the business of dealing with people's lives. And that's the most precious opportunity we get to make or break people with our words, with our decisions, and with our actions. So it's something that we have to hold in the highest regard when we deal with the presenting symptoms. And I'd like to say that child welfare is the exterior, visible symptom of something that needs some attention. I often say that it shouldn't be the children we apprehend. It should be the parents. And because, it's the child that has to leave. It's the child that begins a new journey by themselves, or children, because of things that have happened. And it's really the parents that we need to help and support so that we can bring about change, so they can be in a better position to be the awesome parents that they could be, so that they can provide all of those beautiful gifts to their children of guidance, unconditional love, and the values, the beliefs, and for First Nation people, their identity, their connection to the land, their rights, their culture, their language, their ceremony. Because when they don't get that opportunity, my experience has shown me that you could look at yourself in the mirror, and I often say, do you know who's looking back? Do you know that person in the mirror? For so many of our children, they don't, because they don't have any connection. They don't know where their roots come from. They don't know where their parents are from, who they are, or the communities that they belong to. I would imagine that would be a very daunting task to do every single day, not to know your history, your roots. And how can that provide you to be the most successful that you can be in your potential as you continue the journey, of independence, of your education, your ongoing responsibilities for yourself. It's like a hole within yourself that never heals, like an open space in your spirit. Until you can get those missing pieces, can that gap begin to close so that you could feel whole as a person. So that's where my passion comes from, being able to sit with so many families throughout the years, to be able to say, it's okay, tomorrow's another day, and we're going to work through this together. I'm going to be by your side. I'm going to help you and support you. And together we'll go through whatever it is that we need to get through to get to the other side. And just to be able to have that listening ear, because when you see the children are the ones that have to make the biggest adjustment, in the extenuating circumstances. So, and I did say that before about removing parents. I did do that. In my younger, courageous years, I, instead of relocating the children to, a couple of hours away for foster homes outside the community, I asked the parents if they can go and live with their own families so that the kids could stay home. And we bring in the homemaker. I said, what would you rather have? Them leave, or can you leave for a little while until things get stable so that we can come up with a plan? So instead of foster care, we utilize a caregiver to go in there, like family, to be able to, take care of the children and their routine. Because I don't think it's fair that a child should have to leave their surroundings, their little bed, their friends at school, the family pets. Why do they have to begin a different journey? So that's why I'm really happy to be here today, is because I think and feel that we have an opportunity to do things differently, that we support each other in a collaborative way in whatever capacity you represent in child welfare. These stories, there's many, many, many stories. I've had the privilege of sitting through some of these stories, and that's where the desire comes from. You know, to be able to aspire. We can do things differently. We don't have to continue something that has been not successful, because we have many, many of those stories to share with you if we wanted to. So I think that the more opportunity that we have to come together to share our role, our participation in the big picture is always not a waste of time. And every now and again to come back and look at, is it working? And if it's not, are we going to change it? And if we're not, why not? Because there's a price to pay. We've made contributions to making people stronger, the future generation. And as I often say and acknowledge in my prayers, let's not recreate another generation of child welfare families. Because as long as we continue to practice the same way we've been doing it before, especially for, I could speak for the Indigenous communities. The situation hasn't changed, the environment hasn't changed. We still have water advisories, we still have high unemployment, we still have poverty, you know, that we struggle with. But, you know, that's not everything. I grew up in those environments because way back then, there wasn't a lot. But it does not take away the love and compassion that your parents have for you and your family. So we shouldn't be penalizing and judging our families that way. That has nothing to do with what comes from your heart of being a parent. So the other thing is that the Creator, in my culture, we're taught with values and beliefs, ceremony. I'm going to introduce myself after with my name, is that we understand that the Creator, we are all gifts from the Creator. All children were. And we were a child once that grew up to be adults. So it is our responsibility when we accept that gift to be able to say, I will do my best to provide everything that this child needs. You know, the love, the belonging, the language, part of our culture, because that's who we are. And so I've recently been saying this. I remembered a teaching from an elder who said, people are not possessions that we own. It's not like paying off your car, which becomes your own afterwards. It's not like paying off a mortgage where your house becomes your own. People are not possessions that we own. And the reason why I say that is the society does not own our Indigenous children when you become a Crown Ward. The society doesn't own our children so that you can adopt them to somebody else. We never relinquish that. The children, we never relinquish that responsibility. We never said, here, you could take a turn now. Never. It was always, our history has always taken it away. Through the 50s group, through the 60s group, to the residential care. And we're still carrying some of that pain and that shame that came along with that. It prevented our grandparents and parents from speaking to us in our language. It prevented the practice of acknowledging creation, ceremony, our identity, our right to the land, to fish, to hunt, to sit on the ground and become acquainted with the bigger environment, all living things on the land. So when you take that away, I often think about if you broke somebody's arms and you broke somebody's legs, what is left? But the expectation is you should be able to do well for yourself because we've relocated you. We took you out of one environment to put you in a better environment. How do you expect the bird to fly if you took his wings? They're not going to fly. They're going to crash. They're not going to be able to go anywhere. So the spirit of people, the spirit of our children, especially Indigenous people, that's who I could speak to. It's very dear. I'm going to introduce myself now. In my spirit name, my Anishinaabe and Oswin, I'm going to do a morning prayer, which is about just acknowledging and giving gratitude for a beautiful day today. We acknowledge what's on the land. We call her Mother Earth. And all the gifts she gives us unconditionally every single day so that we can walk and breathe and live here to all living things, not just the human beings, but the animal world, the plant life, the tree life, and all the waters that we need to survive. So we're raised to have respect for Mother Earth, to live in concert with her. She provides for us every single day. That sun comes up, that beautiful sun, and in return, we give gratitude and pay her respect and take care of her so that she can continue to give us life. Just like a mother, just like all of our moms. They brought us into this world, they carried us for 9 months. They have an everlasting responsibility to her children. And so I had the privilege of experiencing that, plus being a grandmother. And it's the greatest honor that one could experience, to be able to nurture them and help create that beautiful journey, to give them tools of what they're going to need, because one day they begin that journey by themselves. And we want them to carry both. It's almost like walking in two worlds. You know who you are, but you also survive in mainstream society to be able to pursue a career and work, the blend of that. That's the way I view the world today, but always being grounded and connected to where I've come from, to my family. So my spirit name is Waseshkakwe. That means woman of enlightenment. And when I got that name, it took me a little while to figure out my name, like what does it mean? Because when you get your spirit name, it kind of depicts the work that you're going to do, the work that you're going to be drawn to. So for me, as a social worker, I had the privilege of sitting with families in situations, that were not so good. But I was able to bring light into that situation, to that conversation, and give them hope that tomorrow will be a better day because we're going to work on it. So the word woman of enlightenment means to bring light, to help bring light into darkness. So I became acquainted with that name. I began to understand even more about my purpose on this journey. So that's what my name means. I come from the Thunder Beings clan. This is my little grandfather. It was this little gift that was given to me. And the Thunderbirds represent leadership, truth, honesty. Because when we get the thunder happening, and the thunder beings, that lightning is going to strike exactly where it's meant to go. So I always have to speak with precision what I'm aiming for, and that guidance, and my prayers and my hopes and my dreams for the people and the families reach the Creator, because the eagle can fly the highest. So I feel very honored and privileged to acquire, those names. So that's part of my responsibility that I have to look after and not steer away from. So this little prayer that I'm going to do is going to acknowledge all of those things. I'm going to do it in my language. I'm still a fluent speaker. I'm very blessed to be a speaker. I grew up with my language, my Ojibwe language, as being the first language in our home. And when I started school, when I was 6 years old in grade 1, I could not speak one word of English because that was the language that my parents raised me at. So I had to learn the English language. And I'm so blessed that I have that. And I know when I was a teenager, I thought, where is this language ever going to take me? Because I grew up in boarding schools and stuff like that too. But I held on to it, and every time I went home, that was the only language I heard in our house, and I was grateful for that. So I'm able to do my prayer and acknowledgments in my language. Habosho, gshemnido, mishumsak, nokamisak, nenemagnak, wasesh kakwe ndego, nimkibeneshis ndodem, kchimigwech manamatsin yiminashiang. Kchimigwech denanash kakmekwe, kinegego gaminashiang, wanakasyang, wimatsiang. Kchimigwech denana mishumsak, nokmisak, geino eajik, bebwibdam shanang nanga, banat moshanang genine, wayne wibzendading, wayne wayne bochding, mi manda dakshkit mine, geine enangsing. Kirangocha benojing, get simon gay no, menes nana win statamot, gabashev soat. Gay no wimna dapnamot, manda matzi nishnabe ad sawin, winim na yad. Mi dakshkit mine, gayaba benojing knacha sinonik. Denabshkokabok, mi mandam nakshkesin, esnakat mageni. Now, miigwech. Oops. So in my language, miigwech means thank you. And we acknowledge the earth, the grandmothers and the grandfathers, and to bring our minds to one today, bring our hearts to one for all of the work and different areas of work that we represent, because it's all about those little ones, those children, so that we can stop and make changes in this generation, so that the next generation will begin to see the results. Investing in people, the adults who make the biggest impact on the children, so that they can grow and heal from whatever ails them. Then we begin to see that in the next generation. So the work that we need to do is not an overnight success, but it's an ongoing success. And the way we're going to do that is by coming together like this, that we all have something to contribute to the big picture and for human beings, for human life at stake. And that's what I prayed for, is that one day we could see that vision of families standing strong again, taking care of each other, so that we don't have to be involved at the intrusive level of protection. Miigwech. Have a wonderful day, and I look forward to listening to all the presentations today, and I'll be back to do some closing remarks. Miigwech.
Yeah, thank you very, very much, Danette. As Danette's mentioned, we're very privileged to have her stay with us throughout the day and help us with the closing. And also a very important reminder, today we're talking about policy and tribunal and court decisions and guidance, that it is the business of people's lives in the end that we're talking about. So thank you for that, Danette. It gives me great pleasure now to introduce Patricia Cossime, our Commissioner of the Information and Privacy Office here in Ontario. Commissioner Cossime has recently, as you may know, last year began a well-deserved second term, building on a very successful first one. We recently released our new strategic plan for 2026 to 2030. Please check that out. The Commissioner is going to come up and speak about further delve into the purpose of today's session and our shared responsibility. So please join me in welcoming Commissioner Cossime.
Good morning. Thank you, everyone. I really want to begin by sincerely thanking Elder Danette Ristoul for those powerful words, her passion, her wisdom, and the enlightenment you bring to this day, reminding us that our work is ultimately about people and their lived experiences, not just laws and policies. We must listen to the voices of our youth and remember that their personal information is not just their data, it's their stories. And by listening to their stories, we can ensure that the work we do reflects their lived experiences as individuals. Today's workshop is for everyone who works with Part 10 of the Child, Youth, and Family Services Act, or what we like to call CYFSA. It's encouraging to see such strong representation from across the sector, frontline service providers, privacy professionals, legal counsel, and organizational leaders, all coming together around a shared priority, supporting the lives of children and youth in care whilst also protecting their privacy. J'aimerais accueillir chaleureusement nos collègues de la communauté francophone. Une interprétation simultanée vous sera offerte à l'écran tout au long de la journée. Je tiens à souligner l'important travail que vous accomplissez tous les jours au service des enfants, des jeunes et des familles de l'Ontario. Souvent, les décisions que vous prenez sont complexes, urgentes et lourdes de conséquences. Ces décisions doivent être informées par des renseignements personnels qui sont recueillis, utilisés et communiqués de façon responsable. I'd like to begin by acknowledging the important work that each of you does every day in the service of children, youth, and families across Ontario. The decisions you make are often complex, time-sensitive, and deeply consequential. And these decisions need to be shaped by the responsible collection, use, and disclosure of and sharing of personal information. Part 10 of the CYFSA introduced a comprehensive framework for managing personal information in the child and youth sector. But as everyone here knows, Part 10 is not just about compliance. It's about trust. It's about ensuring that children, youth, and families can feel confident that their personal information will be handled with care, respect, and dignity, even in the most challenging of circumstances. It's also about the right of individuals who have received services to see or receive a copy of the records to request corrections where needed. And it's about enabling appropriate information sharing so that service providers can work together collaboratively and effectively to prevent harm and support better outcomes. That balance between privacy protection and appropriate information sharing sits at the very heart of Part 10, and it's where many of the real-world challenges arise. Since Part 10 came into force, organizations across the sector have made significant efforts to implement its requirements. You have developed privacy policies, you have delivered privacy training, you have updated your processes and procedures. And yet, questions still remain. How should one obtain consent in complex or evolving situations? Consent by whom and on behalf of whom? When is information sharing appropriate, and when does it cross the line? How do we ensure staff feel confident making decisions in real time, particularly in situations involving potential harm? As you may be aware, the Ministry of Children, Community and Social Services recently developed new requirements for service providers that we will be exploring in more detail later this morning. My office publicly expressed some concerns about these changes and how they could create confusion in practice, and we made several recommendations on how they could be strengthened and improved. But nonetheless, we are encouraged by their underlying policy intent. In particular, these new requirements further limit the use and disclosure of records of individuals who previously received services as children or youth. They also support the ability of individuals, including children and youth, to share their own stories publicly. I'm also pleased to see a new requirement to prominently display information about children's privacy rights, complaint processes, and how to contact my office. These changes underscore an important shift from protecting personal information of others to ensuring that individuals better understand their privacy rights and feel empowered to exercise those rights for themselves. These are not just theoretical questions. They are practical day-to-day realities that affect service delivery, organizational risk, and most importantly, the people whom we serve. At the same time, the environment in which we are operating continues to evolve. Technology is changing how information is created, stored, and shared. And across the sector, there is a growing recognition of the importance of cultural context, including Indigenous data sovereignty and the need for approaches that reflect their communities and their traditions. My office is closely watching how different Indigenous communities are choosing to exercise their jurisdiction since the federal act respecting First Nations, Inuit, and Métis children came into force. Many communities are taking important steps to assume authority over their services, including privacy and access-related matters, and embedding them into their own laws. And as affirmed by the Supreme Court of Canada, these Indigenous laws are, when they are enforced, they will prevail over provincial laws in case of any inconsistency or conflicts. And all of this adds greater complexity to an already demanding environment. Today's workshop is designed to meet that complexity head on. This isn't just about reciting legislation. It's about exploring how Part 10 is being interpreted and applied in practice, identifying common challenges and areas of uncertainty, and sharing insights across organizations and roles. One of the key messages I want to leave with you all today is that privacy and access are not the responsibility of one single role or position. It's not just about the responsibility of lawyers or privacy officers or managers. It is the shared responsibility that runs through every part of an organization. Building a culture where personal information is handled appropriately and where individuals can meaningfully exercise their rights requires more than just written rules. It requires clarity, consistency, and ongoing dialogue, exactly the kind of dialogue we hope to foster here today. As we look ahead, it's clear that questions surrounding Part 10 are not going away. If anything, they're becoming more and more complex. That makes opportunities like this all the more important when we can all come together to ask questions, challenge assumptions, and learn from one another. Before I conclude, I want to announce that in the coming days, my office will be releasing 2 updated guidance documents for the sector. Our Yes You Can information brochure and our guidance on sharing information in situations involving risk of serious harm. Both documents clarify when Ontario's privacy laws allow for, and in some cases even require, the sharing of personal information without consent in situations of potential and serious harm. I encourage everyone to look out for these publications as soon as they're available. I want to thank you again for the time you're taking to attend this workshop, and more importantly, for your continued commitment that you bring to your work every day in the service of children, youth, and their families. I also want to thank presenters, our panelists, our moderator for contributing their expertise, and all of our IPC staff who were involved by near or by far in organizing today's educational workshop. And again, I want to extend my personal and sincere thanks to Elder Danette Ristoul for certainly grounding me in the frame of mind and heart that I will bring to today's discussions. Thank you.
Yeah, thank you very much, Commissioner, and thank you for your leadership and support in helping us bring this day together. Without that, we wouldn't be here. So thank you very, very much. Well, we're going to get into it. So we are going to bring up our start our first session. We have Miranda Clark, Senior Policy Advisor, and James Schneider, Legal Counsel at the IPC. Come on up so you guys can get settled. Who will tell us about the new requirements for service providers under the CYFSA. As they're coming up, yeah, come on up on stage, it's okay. We're going to do our first poll, so you might want to see these results. So as a reminder, answers to the poll and all others that we do today are anonymous. There might be a slight lag online, so we're going to give folks a few seconds. You can see the QR code here. So the first poll question is, there we go. How prepared is your organization to meet the new use and disclosure restrictions and information display requirements? Very prepared, somewhat prepared, early stages, not yet started, or unsure. So we'll give it a few moments here to see. Looks like we have 3 responses. A couple, they're coming in now. Okay. All right, starting to settle out that we have a spectrum from not yet started, early stages, somewhat unprepared and not sure, with the smallest portion very prepared. So insightful. Thank you very much for that. You can keep voting and we'll capture those results. And with that, I'll hand it over to our speakers for the first session. Thank you very much.
Okay. All right. Good morning, everyone, and thank you for being here today. In this presentation, we will be exploring what's new in the CYFSA related to personal information. Okay, so before we dive into some of the legislative and regulatory updates that the Commissioner was just mentioning, I'm going to start by providing a high-level overview of Part 10 of the CYFSA. So Part 10 of the CYFSA establishes privacy and access rights for service recipients and sets the rules that service providers must follow to protect privacy and enable access to personal information. The key elements of Part 10 are service recipients' rights to access and correct personal information, rules governing service providers' collection, use, and disclosure of personal information, including consent and capacity requirements, requirements for service providers to safeguard personal information, breach notification obligations for service providers, and oversight by the Information and Privacy Commissioner. In general, the rules of Part 10 apply to service providers delivering services under the CYFSA. This includes children's aid societies and Indigenous child and family well-being agencies, adoption and residential licensees, and in some cases, the Ministry of Children, Community, and Social Services. Under Part 10, any person may file a complaint with the IPC about another person who has or is about to contravene Part 10. This could include complaints about refusal of an access or correction request or failure to respond, privacy breaches including unauthorized collection, use, or disclosure, or inadequate privacy safeguards or security measures. Also, failure to comply with any Part 10 requirement. In response to complaints or on its own initiative, the IPC may choose to conduct a review of any matter involving a possible contravention of Part 10. Where possible, the IPC promotes informal and early resolution of complaints, and often does this through mediation. In some cases, such as a privacy breach, the IPC will appoint an investigator to gather and clarify the facts relating to a contravention or potential contravention of Part 10. If a complaint is not resolved at an early stage, the IPC may decide to conduct a formal review, and in this situation, an IPC adjudicator will be assigned. You will hear more about the IPC's complaint process and our Part 10 orders and decisions later this morning. Okay, as mentioned above, service providers must take reasonable steps to protect personal information in their custody and control against theft, loss, or unauthorized collection, use, disclosure, copying, modification, or disposal. There is no precise definition of a reasonable step. What is reasonable depends on the circumstances. It will change as you use new technologies and as new threats or vulnerabilities emerge. When determining how to protect personal information, service providers should assess the nature of the records, including the sensitivity and amount of personal information in the record, the number and nature of people with access to the information, and any threats and risks associated with the manner in which the information is kept. Based on this assessment, service providers should put in place measures to safeguard privacy. These measures should be regularly reviewed to ensure that they continue to be reasonable. In many cases, reasonable measures will include administrative, technical, and physical safeguards, such as those detailed on this slide. We're now going to shift our discussion to the new use and disclosure restrictions, which were developed by the Ministry of Children, Community, and Social Services. So as part of Bill 188, the Supporting Children's Futures Act, the ministry amended the CYFSA and the Personal Information Regulation by introducing new use and disclosure restrictions. The coming into force date of these new restrictions has not yet been formally announced. It is important to note that MCCSS developed these new restrictions. As the privacy and access regulator, the IPC's role is to oversee Part 10. The ministry's stated policy objective for these new use and disclosure restrictions was to further protect the privacy of individuals with previous involvement with the child welfare sector. The IPC, as the Commissioner mentioned, did provide comments and feedback to the ministry on both the legislative and regulatory amendments, and this is available on our website for you to review if you're interested. Okay, so what do these new restrictions do? Once in force, these restrictions will limit staff working for children's aid societies and prescribed entities from using or disclosing certain records of personal information. These restrictions generally apply to records of personal information collected when an individual was a child or youth and the individual is no longer eligible to receive care and support. The information must also be held in a prescribed record or in a record related to care and support services received under Section 124 of the CYFSA, for example, the Ready, Set, Go program. So what are the prescribed records? The prescribed records are information held in records that were collected by a society primarily for the purposes of performing its functions under Section 35(1) D to G of the CYFSA. This means information held in records that were collected by a society primarily for providing care to children assigned to its care, supervising children assigned to its supervision, placing children for adoption, and performing any other duties under the Act or its regulations. So it's important to note that this means that the new restrictions do not apply to information held in records that were collected by a society primarily for the other functions listed under Section 35(1), which include investigating allegations or evidence that children may be in need of protection, protecting children where necessary, and providing guidance, counseling, and other services to families for protecting children or for the prevention of circumstances requiring the protection of children. So now that we have reviewed the general framework of Part 10 and I've introduced the new use and disclosure restrictions, I'm going to pass it over to my colleague James to talk more about the content of these new restrictions and how they may differ from existing obligations under Part 10.
Thank you, Miranda. Thank you, Miranda. So this is going to be a bit of a deeper dive into what the new restrictions do and when there are still permissible uses and disclosures under the provisions of Part 10. So again, thank you, Miranda. And Miranda's talked about what these new restrictions, the kinds of records they apply to, and the circumstances in which they apply. So let me talk about the exceptions to these restrictions. In other words, what are the permissible uses? First, I'll talk about permissible uses, and then permissible disclosures. And again, these are different from the existing permissible uses and disclosures in some cases. So that's why I'm going to get into some details. So first, you find the new exceptions or the permissible uses in both the Act itself, the CYFSA Part 10, and also in the regulations. So you have to look at both to find out what are permissible uses or disclosures. So first, what are the permissible uses, the ones you find in the Act itself? And this is a new provision. I'm going to say the provision. I'm a lawyer. I can't help myself. So you can look it up later. 291.1 sub 2. Okay. So what are the permissible uses with respect to these restricted records? Providing information by a children's aid society or what the Act calls a prescribed entity, which has been requested by the ministry. That's permissible use. Responding to requests for access to personal information, complying with the IPC's, our office's inspection and review powers. Okay, so those are the ones in the Act. Then there are more in the regulation. So what are these ones? Complying with a record correction request, complying with the safeguard and standards for reporting under the Act that are already there. So those are fairly straightforward. But I want to focus on the next two. These are the ones which I think if you're in the field, you're going to want to pay attention to. So permissible use is with consent, and the Act uses interesting language, giving effect to an individual's consent to disclose personal information when necessary for a lawful purpose. So with consent, when necessary for a lawful purpose, or to comply with a court order. And complying with a court order includes for the purposes related to addressing a serious risk of harm. So that's very different than the existing permitted uses. There's no need to get a court order to address a risk of serious harm under the existing permitted uses. So pay attention to those two. And when you look at some of the existing uses, there are things like, of course, there's responding to a risk of serious harm, using personal information in a legal proceeding, and another one that exists now and is different is where permitted or required by a law, a treaty, or an agreement made under one of these laws or treaties. So that permitted use no longer exists. Instead, you're going to have to go back to complying with a court order or with consent when necessary for a lawful purpose. Oops, sorry, thank you. Changing the slide. Right, so these actually are in the slides, but of course I got all excited and I forgot to advance the slides. Let me just get ahead here. Yeah, there's the, no, it's okay. I think I'll try to remember now. Okay, so those are the permitted uses. Let me switch to permitted disclosures. And again, this is, the Act talks about this as exceptions to the restrictions on disclosure. So again, some of these are the same under the new permitted disclosures with consent when necessary for a lawful purpose. Oh, actually, let me start with the ones that are in the Act first. Again, these are similar to the ones that are in use, providing information to the ministry, responding to access request, complying with IPC inspection and review powers. Okay, and then you get into the regulations. Again, some of them are the same. Consent, with consent, when necessary for a lawful purpose or complying with a court order. And again, including with respect to assessing, reducing, or eliminating a risk of serious harm. Then there's a whole bunch of other stuff. I'm not going to read all of those. They are in the slides. There's things like facilitating the duties of various public officers, like the Auditor General, our office, the Ombudsman. One, which I will flag here, which is the bottom one, oops, sorry, on that last slide, is, yes, to comply with any legal requirement. And then there's some more details there, but to complying with any legal requirement. So that's a permitted disclosure, but again, there's no equivalent permitted use for that. So again, I would pay attention to that if I were in the field. And then we have a whole bunch of other stuff, successors, providing it to an organization involved in statistical analysis, planning, and management. These are the prescribed entities under the Act. Record correction requests, permitted disclosures in relation to substitute decision makers, so some kind of practical things. But there's a longer list of permitted disclosures and a much shorter list of permitted uses. So again, a distinction there to pay attention to. And the other thing I would just flag is that one on the last slide that I mentioned, the applying with any applicable legal requirement, that is actually different language. There's similar-ish language in existing permitted disclosures. That's about if permitted or required by a law, but this says to comply with a law. So again, that's a tighter, it's not just permitted, it's to comply with a law. So that difference in language may be important. Okay, I've gone through these. All right, so how do these new ones, these new restrictions differ from the existing Part 10? So I kind of talked about that a little bit, but I want to kind of highlight what some of these are. There are, of course, additional restrictions on use and disclosure. That's the main difference. These are different, and they're additional. The key ones I would flag in terms of the difference is that you may need a court order or consent if you're using personal information to meet certain legal requirements. This includes addressing a risk of serious harm, potentially responding to a lawsuit. So, give yourself the time to think about whether you're going to need a court order to do that if you're dealing with some of these new, or some of the records that are subject to these new restrictions. And again, the new regulations do not include a use for complying with any legal requirement, but they do provide a permission for disclosure when complying with any legal requirement. So differences in terms of what you can do, what's a permissible disclosure and a permissible use, much tighter on the permissible uses. Right. Oh, yes, of course. So the other kind of two things that are in the differences, these new restrictions don't apply to all service providers. So of course, as you know, under Part 10, it's mostly now about service providers. These new restrictions are to societies or prescribed entities. So they don't apply to everyone. And the other one is that, of course, as I kind of talked about, they require, it's a different analysis about what you can use and disclose. It's not just about, you're not, under Part 10, if you're operating there now, you're thinking about in relation to the provision of a service. That's sort of when uses and disclosure restrictions kick in. Here, it's more about the type of record and the functions you're performing when you create that record. So again, pay attention to those differences. Yeah, okay. Okay, so I'm going to pop into a couple other, these are a bit more general now, to some other new requirements that are going to apply to societies or service providers. And this one is under Part 10. There are new information display requirements. I'm not actually going to read everything on this list about what is entailed in these new obligations, but I think it is important, if you're not already aware, that these will come into force on July 1st of this year. So make sure you've looked at what these requirements are. We have some information here at our booths, and they'll be available and are available online in terms of hopefully providing you with some assistance in terms of meeting these obligations. But these are about making information available to children and young persons around what their rights and interests are and, in relation to the CYFSA. Okay, so here's another one I want to flag, another new change that's coming into force on July the 1st. This is not under Part 10, but it is in the CYFSA, and it does deal with important aspects of privacy and transparency, so that's why we're including that today. And these are changes to the current publication ban that exists in relation to child protection proceedings. So right now, I'm not going to go into what those are existing ones, but there are protections with respect to young persons. And there are also restrictions on others involved in those proceedings in terms of what you can publish or make public. So these new changes, again, coming into force on July the 1st, are primarily intended to allow individuals who are or were in care to talk about their own experiences without going to court to get a judge to lift the existing statutory publication ban that would protect that information. And what I want to talk about here, which I think is important if you're kind of trying to think about how this might affect, if you're working in this sector, how it might affect you, I want to flag that it's an exemption approach to the publication ban. So if you're used to working with publication bans, or if you're used to the restrictions that apply here, it operates a little bit differently. It does exactly what I just said it did. It's intended to promote the ability of young persons who are in care to talk about their stories, but it doesn't do that by allowing them to lift the publication ban, which is usually how publications ban work. Usually they're an on-off switch, right? Either there is one or there's not, and usually it applies to the world or to no one. But under these new guidelines, they create an exemption. So a young person can talk about their experiences, and then that triggers a bunch of other stuff. So that may broaden the exemption. If you've been identified in that kind of, when that information has been disclosed, you may be able to yourself talk about it. But the publication ban may still apply to other people, like third parties and journalists. And for those individuals, if they want to talk about these things, even if they have been disclosed by the young person or a former young person in care, they may still have to go back to court or get consent to also talk about those issues. So that's, in a nutshell, what this publication ban changes are about. There's a lot of details in the regulations, and that's not under the personal information regulation, it's the general regulation. So I'm not going to name those, but you can go and look at those. And I would encourage you, if you're in the field, to look very carefully about the nuances of how these new exemptions are going to work. Yeah. Okay. So the last new kind of set of rules and obligations that I want to flag here is actually under a different piece of legislation, not under the CYFSA, but because they're going to affect societies, we thought it was important to talk about that. And and they kind of overlap with some of your existing obligations under Part 10. So there's this new legislation called the Enhancing Digital Security and Trust Act. And this has received royal assent, but again, some of the provisions are coming into force on July the 1st. So what this does, this legislation does kind of three big things. It sets out new cybersecurity measures that some organizations are going to have to comply with, and societies are included in that. It also does stuff like establish rules relating to digital technology affecting children. So cutting to the conclusion on that, those are not going to apply to societies or service providers. So you don't have to worry about those, at least not for now. And then there's a third piece of this legislation, and it's going to potentially set up guidelines around the use of artificial intelligence. So those may or may not apply to you, and you'll have to wait and see, because we don't know yet. But the ones that we know are going to apply, at least to societies, and I guess I should flag here that it's not all service providers, it's actually just societies. Those are going to, let's see what those say. Yeah, so these are the new ones that are going to apply. Again, those are coming into force on July the 1st, and they're going to create certain obligations in terms of cybersecurity safeguards. So these are going to be, I don't want to read all of this, but one of the things I want to flag is that, so there's certain point persons you have to establish, you have to do certain things around implementing cybersecurity measures, and there's more details that I'm not going to go into. But one of the other things is, if you've experienced what's called a critical security incident, critical cybersecurity incident, then there's a new reporting obligation to the ministry under this. And you have to do that, make that report within 72 hours. And I want to flag this because you already have obligations under Part 10 in terms of reporting to our office, the Information Privacy Commission. So this is a second set of reporting obligations. And lucky you, it's got a different threshold and different standard for when you have to report. So I just want to flag that. The regulations here define critical security incidents, and though the definitions of that include issues around there being a risk of harm criteria to meet. So when, I'm not going to go into the details of what those are, but I want to flag at a high level. If the cybersecurity incident has various risk of harm criteria, if those are met, then your obligation to report to the ministry is going to kick in. You're still going to have an obligation to report to the IPC, to our office, with respect to cybersecurity incidents that relate to breaches of personal information. So you may have to report to two bodies. And I guess, again, pay attention to the fact that there's a different threshold. One involves a risk of harm, and one just involves the loss or use of personal information. And lucky you, again, you get to hear me talk more about that later in another session, about what what your obligations are under Part 10. Okay, so yes. So those are the new things that are coming under that act. And I have a couple key takeaways. Wow, I'm actually going more quickly than I thought I was going to go. So I hope I haven't been going too quickly. But what are my key takeaways in terms of all these new kinds of obligations, roles, responsibilities, regulations that are going to be impacting some of you here today? So there are a bunch of, so all of these new things have been enacted, but they're not all in force. So what are the key ones? The new use and disclosure restrictions. These are coming into force soon on a date to be named by proclamation, but we don't have an official word on what that is. But I would look out for those and expect that could happen very soon. So if you haven't already turned your mind to how you're going to start thinking about complying with those new restrictions on permitted uses and disclosures of personal information, now is definitely the time to think about that. And you can find all those obligations both in Part 10 and in the regulations under Part 10. What else? What is coming into force? So those are coming into force soon, but what we know are coming into force, at least when, on July the 1st, are the new display information and display requirements, the new publication ban exemptions, and these new cybersecurity related obligations that are under the enhancing digital security and what's the T stand? Trust, Enhancing Digital Security and Trust Act. I love an act with a lot of names in it, words in it. Anyways, so those are my key takeaways on some of the new obligations that are coming your way very soon. And I think that leaves us with plenty of time for questions. And I would say maybe, Miranda, should we go and like share? We've got 2 mics here. We could do it. I'll stay sitting. Oh, come on. So, oh, okay. Yeah, I don't know how this actually works.
No worries.
Thank you.
Yeah, thanks, James Aranda. So as I mentioned, we do have the QR codes for Slido, and we do have a roving mic for questions. So we'll see what starts to come up, and we'll be obviously monitoring for those who are participating virtually for your questions online. So back to you guys.
Mike, do we go there or here? We go back there.
Yeah, you can come here. You can. The mics on the table are good? Yeah, either one is good.
Okay.
So I'm assuming we're going to see these questions
Sandra's
over there.
gonna
Okay,
read them
perfect.
to us.
Oh, thank you.
Okay, if there's, I don't want to preempt somebody in the room, but one of the questions from online is, should executors be permitted access to records?
Wow, that's an interesting question, which I have never turned my mind to.
Well, this is the issue around deceased individuals.
Oh, deceased individuals.
Right? Yeah, I think so. Around whether they should be able to, the issue around decision 13.
I can't remember that one. I can't remember the answer to that one.
Yeah, I think we're lacking a little clarity on what the question is. I don't know if they're adding additional. But I would assume that the question is around information of deceased individuals, potentially related to the IPC's decision number 13. Okay, I'm seeing a thumbs up, so I feel like I'm on the right track. Yeah, I mean, I don't know that there's much that we can say about that. You know, as the IPC, we're responsible for oversight of the laws, so I don't know if we can answer whether you should have access, but our decision number 13 speaks to the issues around access to deceased individuals' information, and you will also note that if you're interested, the IPC has our CYFSA 5-year review submission available online, and in there we also make some recommendations to the ministry about how the CYFSA in Part 10 specifically could be strengthened to make that clearer, and so I would suggest maybe taking a look at that if you haven't already.
And if you think that kind of clarity would be of assistance, again, you know, the place to raise those concerns. You can raise those with us as well, but as Miranda said, we oversee Part 10, but we don't actually hold the pen on legislative changes that might clarify in that area. So that's something that others can look at and raise with the ministry if they feel it would be helpful. That's maybe not the answer folks wanted, but
It's the answer we have.
yeah.
Okay, does data minimization apply to information from prescribed records requested by the minister?
So that's about, the obligation to provide only the personal information that, sort of meets the purpose, right? Like there is an existing, that's a general principle under Part 10. So I actually don't have the legislation in front of me to read the exact provisions, but it's a general requirement. So without looking at the legislation, I'd say, please make sure. Generally, that's generally the rule, that you required only the information necessary to fulfill the purpose. So subject to a specific provision otherwise that overrides that, you would generally be the expectation would generally be that you do meet data minimization obligations. Yeah.
Okay, what does the ban relaxation on young people's story mean for young people?
Oh, well, I think Miranda, you can jump in on this too, but I think it does certainly mean that it gives them more power, more ability to tell their own stories. I think it clearly does that. You don't have to go to court to get a judge to allow you to talk about that anymore. You can do that. You can exercise, or young people can exercise that right on their own initiative. And I think there continue to be some other restrictions that do apply with respect to those things. So I think the ministry has made an effort to kind of balance the existing protections of the publication ban with more agency for young people to tell their stories.
Good answer.
And I think we're almost at time, so we'll make this the last question. How will this affect what's being redacted when youth access their files?
I'm assuming that's in relation to the new restrictions.
Is it? Well, I haven't turned my mind to this, but I think my understanding of this question is how will the new use and disclosure restrictions apply to access to information requests so when someone has a right of access under the Act, will this change that? Well, okay, so again, being a bit of a lawyer here, caveat, what I say is my own personal opinion because this is speculative and subject to what our tribunal might decide if ever received a complaint and had to adjudicate this. Nothing binding on what that might be, but on the face of it, I don't see the existing access provisions changing. I mean, these are restrictions on use and disclosure by societies, by prescribed entities, not in terms of what is accessible to an individual trying to access their own information. Yeah. And in fact, there are clear exceptions for use and disclosure in relation to access to information requests. So that's probably the quick and dirty answer. Yeah. Shouldn't change.
Yeah.
Wow, I think I knew the answer to that.
You did, yeah. There we go. Okay.
Oh.
Is there one or two other questions?
Sure. Oops. Sorry, excuse us. Will the publication ban exemptions balance the rights of the individual with the privacy of other involved persons like siblings?
That is a great question. I mean, I think what I will say first is that this is a question that our office is concerned about, and wanting to raise that as a consideration, a concern in terms of when these come into effect and the publication ban is relaxed. So if you look at the way the regulations work now, there are a couple things there are some restrictions that still apply. When a person is exercising their new rights to talk about their stories, they can't talk about other children that were involved in those child protection proceedings if they're still children at the time of publication. However, someone who was a child but is now an adult, they may be able to talk about those individuals. So there's a pretty complex scheme about who you can and can't talk about and what you can and can't disclose. So someone else who was the subject of the same child protection proceeding can't talk about them without consent or judicial oversight. A child witness or participant, you can without consent or judicial oversight. So this is where I say, I'm not going to speak to whether it's the right balance, but clearly I think the ministry's certainly turned its mind to this, and there's a lot of detail in the regulations about what you can and can't talk about, and who you can and can't talk about, and about who can then also talk about those same things. So it is pretty detailed, but that's my high level. That's my answer on that. Miranda?
One more?
No, I was going to say, do you want to?
Oh, no.
Okay.
No, I'm good. One more question, yeah.
Okay. One of the slides mentions successors, so how do the new regulations apply with agencies' obligation for First Nations consultation?
I mean, that's a fantastic question, which I don't have a clear answer on. I mean, there is one of the permitted disclosures is with respect to successors, but it's successors the way the Act defines it now, which is restricted. It's about successors who are basically successors under the CYFSA. So that doesn't really help, clearly. Again, subject to whatever anyone may interpret in the future about what these things mean. I think there's a real question there, and I don't know the answer to that. There was one of the permitted disclosures was to comply with the law, is to comply with the law. So that may be some place to look and to think about whether that allows for disclosure in respect to this question, but I don't know the answer to that. And I think it really is a really important, outstanding question.
Yeah. And we would encourage continuing to seek clarity from the ministry on that question.
Yeah.
Great.
Thank you.
Thank you.
Thank you very much.
Yeah, thank you very much, Miranda and James, for that presentation. Wanted to get a couple more questions in there as we're just a little behind time, but as I said, I want to make sure we maximize getting Q's and A's from you. That's very helpful. A couple things to flag. A few folks have been asking, will we post the slides? We will. If you take a look back at our MFIPA session, you'll see we've posted all the presentation materials after the event, along with a video of today's proceedings, so keep an eye on that. As well, I just wanted to highlight on your tables, you've got the little postcards highlighting our Info Matters episodes and key ones for you to check out, so please do, and if you're not following us there, I encourage you to do so. We are going to, we just got some refresh and some treats outside. If we could get back here by 11, we'll get back underway. Thanks for a great start to the morning, everyone, and thanks to everybody who's presented so far. Take care of yourselves. See you soon.
Access to government information is essential to a healthy democracy. It provides a window into government decision-making. It supports accountability and transparency. It fosters civic engagement. But if you've never filed a request before, the process may seem a little daunting. So here are a few tips. 1. Think about which government department may have the information you want. 2. Use the access request form available on government websites. Filling it out and submitting it is quite straightforward. 3. If you're not sure how to phrase a request, ask the institution. They have an obligation to help you. 4. Be as specific as you can. It'll help make the process more efficient. 5. You can file an appeal with the Information and Privacy Commissioner of Ontario if you believe your access rights have been denied. To learn more about access to information rights under Ontario's laws, visit ipc.on.ca. More and more, we are living our lives online and using technology in all kinds of helpful and innovative ways. Organizations collecting personal information need to follow certain rules to protect data, but individuals also have a role to play. How can you get the most out of the online world and protect your privacy? Here are 5 tips. 1. Look into what a company does with your information before choosing to download an app. 2. When available, use multi-factor authentication to access your online accounts. This means using more than just a username and password, like a special access code sent to your smartphone. 3. Tighten up those privacy settings. Don't just stick with the defaults you're given. 4. Think before you share something about yourself or someone else on social media. 5. Push back on companies that ask for too much personal information. Limit what you share to only what's necessary to get the product or service you want. You know, there are lots more ways to be privacy aware. For tips to protect privacy and to learn more about your rights under Ontario's privacy laws, visit ipc.on.ca. Access to government information is essential to a healthy democracy. It provides a window into government decision-making. It supports accountability and transparency. It fosters civic engagement. But if you've never filed a request before, the process may seem a little daunting. So here are a few tips. 1. Think about which government department may have the information you want. 2. Use the access request form available on government websites. Filling it out and submitting it is quite straightforward. 3. If you're not sure how to phrase a request, ask the institution. They have an obligation to help you. 4. Be as specific as you can. It'll help make the process more efficient. 5. You can file an appeal with the Information and Privacy Commissioner of Ontario if you believe your access rights have been denied. To learn more about access to information rights under Ontario's laws, visit ipc.on.ca. and more, we're living our lives online and using technology in all kinds of helpful and innovative ways. Organizations collecting personal information need to follow certain rules to protect data, but individuals also have a role to play. How can you get the most out of the online world and protect your privacy? Here are 5 tips. 1. Look into what a company does with your information before choosing to download an app. 2. When available, use multi-factor authentication to access your online accounts. This means using more than just a username and password, like a special access code sent to your smartphone. 3. Tighten up those privacy settings. Don't just stick with the defaults you're given. 4. Think before you share something about yourself or someone else on social media. 5. Push back on companies that ask for too much personal information. Limit what you share to only what's necessary to get the product or service you want. You know, there are lots more ways to be privacy aware. For tips to protect privacy and to learn more about your rights under Ontario's privacy laws, visit ipc.on.ca.
Big body. Take a ride with me, babe. You by my side. How does it sound? You and I. Oh, girl. Take a ride with me, babe. You by my side. How does it sound? You and I. Baby, take a ride with me, babe. You by my side. How does it sound? You and I.
Okay, folks, if you could just grab your coffee and any snacks and make your way back to your seats. We're going to get underway in a minute. Okay. All right, welcome back, everyone. For our next session, we are going to learn about the IPC's tribunal processes, key tribunal decisions with a focus on practical takeaways and lessons learned, and end with an update on a recent court decision. But first, I have our second poll question. We want to put that up on the screen. Which areas present the greatest operational challenge for your organization today? Managing complex requests, meeting timelines, interpreting exemptions, navigating tribunal processes, documentation, defensibility, or resource constraints. Let's see what we got. I think that's 2 responses. Let's give it a sec. Okay, meeting timelines, resource constraints, not a surprise there. Navigating tribunal processes, a timely one that we can hopefully bring some clarity to. And managing complex requests. We'll let the votes still come in for a sec while I'm introducing our panelists. So for our second session, I'd like to introduce, I think in order here, Suzanne Brocklehurst, Director of Early Resolution, John Gale, Acting Manager of Investigations, Stella Ball, Adjudication Manager, and James Schneider, who's back, Legal Counsel. They're going to tell us more, as I said, about the IPC's tribunal processes and key decisions in court cases. So over to the panel. Thank you very much.
Okay, it's nice to see everyone here today. We're very happy to be here to talk to you about what the tribunal does. I'll be giving an overview of the workings of the tribunal, the types and the number of cases that we've been receiving since Part 10 came into force in 2020. And then I'm going to shift gears and speak briefly about cyber attacks and the Early Resolution Department's role in reviewing those that are reported to our office. Okay, so since 2020, the IPC has seen a steady number of cases come before its tribunal under Part 10. For the past 2 years, we've seen a total of about 160 cases each year. So of the 161 cases we opened last year under Part 10, 44 were received from individuals who made privacy complaints to our office. 58 were complaints related to requests for access to information or correction of information. And 59 were breaches that were reported to our office by service providers under their mandatory breach reporting obligations. Sorry, there we go. Okay. So of the 162 cases that we closed, so we closed one more than we opened last year, which is good news, 126 were either resolved or screened out at an early stage. That means they could have gone through a mediation, an early resolution, or been processed by our expedited team. The average time taken to close a file overall was 9.8 months. I should note, however, that of the cases that were resolved or screened out at the early stages, the average time taken to close those files was generally under 6 months. So now I'm going to give you a brief overview of the stages in the tribunal you may come into contact with if you have a case with us. Our intake team, led by our registrar, is responsible for the initial assessment of all files that come into our office. They determine which stage to send the file to based on jurisdiction and the type of case. If it's an access complaint, a privacy complaint, or it's a breach that's reported to our office. This team also gathers the necessary information to ensure files are complete and ready to be worked on. The intake team also screens out matters that are not within the IPC's jurisdiction or, for example, are late being submitted, and we won't accept those. The early resolution stage deals primarily with privacy complaints from individuals and privacy breaches that are reported to our office. The goal is to resolve cases in a timely manner. If a resolution is not possible, the analyst assigned will decide if the file should be dismissed or if it should move to another stage. A case will be dismissed when an analyst is satisfied that a breach, for example, hasn't occurred, or if one has occurred, is satisfied with the steps taken by the service provider to remedy the breach. A case will be moved to a formal investigation if the service provider has not responded to the breach in a reasonable way or, for example, is not cooperating with our process. Our expedited team deals primarily with access complaints related to preliminary issues. For example, if a service provider has not responded to a request within 30 days, a deemed refusal, they've granted access to records, but then they fail to disclose them to an individual. There's a search issue. The individual who made the request feels that more records exist or wasn't provided with records that they expected. If there's a fee or a fee estimate dispute, if the service provider has claimed a time extension. Those are some examples of cases that would be dealt with at the expedited stage. And the goal here is to also resolve matters in a timely manner. However, if a resolution is not possible, the case lead assigned will decide if the file should be dismissed or if an order should be issued in the case. And that stage generally deals with matters from start to finish. Our mediation team deals with access complaints. So our mediation team also falls under our investigation team, and these folks are dealing with access complaints related to the denial of access to records. And the goal here is to mediate a settlement in a timely manner to the satisfaction of the parties. And if a mediation is not possible, the file will move to our adjudication stage. So those are the examples of the early stages of our process where we really stress trying to resolve or dismiss as many cases as we can at this stage. However, there are cases that we do have to move to a more formal stage. One of those stages is our investigations stage, where they primarily deal with privacy complaints and privacy breach files from organizations that involve novel or very complex issues, including those with significant public interest. The goal here is to gain compliance with the respondent. If compliance is gained, the investigator will issue a public report. If compliance is not met, the file will proceed to our adjudication stage. And the adjudication stage is the last stage in our process. This team deals with all file types under all jurisdictions, and they deal with those files that can't be resolved at earlier stages. They conduct a formal review, and at the conclusion, the result is generally that it will result in a formal decision that can include binding orders. So now I'm going to switch topics. Hopefully it just not too much of a non sequitur, but I'm going to talk a little bit about cyber security, the incidents that we've seen coming before our office. It's an important topic. Every service provider does have an obligation to protect the information before them, and we've seen, it doesn't come as a surprise, that we've seen an increase year over year in the number of cyber attacks reported to our office. And as you know, the impact a cyber attack can have on a service provider can be devastating and can involve the shutdown of important services. Cyber attacks can also have severe impacts on individuals by compromising their personal information and in some cases putting it into the hands of criminals who may retain it and sell it on the dark web. Once data is posted there, it's essentially impossible to remove. Since 2024, 190 cyber attacks were reported to the IPC. The bulk of the cases were reported under the Personal Health Information Protection Act. And while only 5, congratulations to your sector, were reported under Part 10, it's very important to be aware of the dangers of a cyber attack and ensure you're prepared. You may not know that approximately 80% of all cybersecurity files that are resolved at the early resolution stage. Typically, the resolutions and decisions of this stage are not publicized. But as many cyber attacks are in the news and affect many people, we've started posting some of our closing reports for high-profile cases on our website under a new page called Informal Resolutions of High-Profile Breaches. By posting these closing reports, we can ensure that we're responding to the public's interest in these cases, including those individuals that were affected by the breach. We can ensure that we highlight important trends and issues with regard to cybersecurity. In addition, these reports include key takeaways and provide educational opportunities that may benefit other organizations. At early resolution, we are focused on ensuring that service providers that have experienced a cyber attack have taken reasonable steps to contain the breach, notify affected parties, and implement remedial measures to mitigate future attacks. Resolving cybersecurity cases at the early resolution stage saves everyone time and resources. It's important to cooperate with the early resolution team when reporting a cyber attack to the IPC. While not every case is suitable to be resolved at early resolution, 80% are. So just generally, I'm going to give you an overall of the common themes for cyber attacks that we've seen reported to our office. And essentially, the most common theme is that organizations lacked basic industry standard protections. In many cases, had the organization implemented these basic protections, the attack likely would not have occurred. Or if it still had occurred, the impact would have been much less severe. Some examples of industry standards that were not in place include that there was no multi-factor authentication. Multi-factor authentication means you need more than just a password to log in. Usually a password plus a code sent to your phone or a generated app. We emphasize this because several major breaches we've reviewed could have been prevented or the impact significantly limited if multi-factor authentication had been in place. Weak or network segmentation is another cause. Network segmentation means dividing a computer network into separate sections so that if an attacker breaks into one section, they can't easily move to others. Several cases we've reviewed show that weak segmentation allowed attackers to access far more data than they otherwise could have. Another common theme was that credential theft guards were not in place. Credential theft means an attacker obtains someone's username and password. This has been the cause of several breaches we've seen. At one school board, a threat actor obtained login credentials through social engineering and then found additional passwords saved in a web browser, allowing access to further data. In another case, an employee reused the same password across multiple websites, allowing the hacker a vector into the institution's systems. In yet another case, attackers used stolen credentials to move between affiliated company systems. All these cases highlight the importance of having measures in place to prevent credential theft. Another common theme was that there was weak or no training. We found that organizations did not conduct regular cybersecurity awareness training. That includes segments on phishing and other social engineering attacks. If staff are regularly reminded of how to detect and respond to cyber attacks, it will keep it top of mind and add to a service provider's arsenal of protections. Another is poor password hygiene. This is just very simple things that we can do. We found in some cases reviewed at early resolution that this was the cause of a cyber attack. Service providers must ensure that their employees use unique and complex passwords. The reuse of stolen passwords is a major phishing threat. One other is insufficient protection of legacy systems. So legacy systems are older computers or software that may no longer receive security updates from the manufacturer. Without these updates, known security flaws remain open for criminals to exploit. In several cases, the IPC reviewed organizations continued to use systems that were end of life or unsupported, creating entry points for attackers. Not keeping systems up to date is one of the most common and avoidable mistakes. So those are some of the things that we found, common themes. There's some others on the screen. But there are many things that you can do to protect yourselves. You can start with reviewing guidance from our office and other organizations such as Cybersecurity Ontario or the Canadian Centre for Cybersecurity. I'll pass things over now to my colleague John Gale, who's our Manager of Investigations, who's going to review a case that concluded at the investigation stage. Thank you.
Okay, good morning, everyone. As Suzanne mentioned, my name is John Gale. I'm the Acting Manager of the Investigations Department at the IPC. Thank you for joining us here today, as well as online. Today I'm going to speak for a few minutes about the IPC's role at the investigation stage with respect to Part 10 of CYFSA, and also discuss one of our decisions issued under this legislation, CYFSA Decision 26. This case involved unauthorized access to child welfare records and provides some practical takeaways that are relevant for service providers under this legislation. Okay, so what do we do at the investigation stage? We aim to resolve access to personal information complaints as well as personal privacy complaints that are made to the IPC. Doing so typically involves the investigator contacting the parties and gathering facts, clarifying the issues in dispute, facilitating a resolution where possible, and identifying corrective actions to address the access or privacy issues raised by the complainant. Possible outcomes at the investigation stage include the complaint being resolved, issues being narrowed, a public decision being issued, or the matter proceeding to the adjudication for a possible review. It's important to note that investigations are not just about what went wrong. They're also about what needs to be fixed to ensure compliance with Part 10 going forward. A good example of this is CYFSA Decision 26. Okay, so what happened in this case? This decision, or this case rather, involved unauthorized access to personal information in contravention of Part 10. Unauthorized access is often referred to as snooping, and it may be motivated by curiosity, personal gain, interpersonal conflicts, or just simply concern for the individual or individuals to whom the personal information relates, as the case may be. Nonetheless, let me be clear, unauthorized access, regardless of the motivation, is still unauthorized, and such action is not in accordance with Part 10. In this case, a Children's Aid Society reported multiple unauthorized accesses to records in CPIN, that is the Child Protection Information Network. 9 employees accessed files without a work-related reason, and in total, 73 family files were accessed inappropriately. These files contained highly sensitive child welfare information. In response to the breach, the CS conducted an internal investigation, notified affected individuals, and also ensured that they reported to the IPC. One of the key issues for us at investigations was whether reasonable safeguards were in place as required under Part 10. So what did we find? We found that reasonable safeguards were not in place at the time of the breach. Some of the key gaps included inconsistent privacy training, confidentiality agreements that were not renewed annually, there were no system privacy notices, and the policies and procedures were also inadequate. The CS later implemented corrective measures to address these deficiencies, and we were satisfied ultimately that the appropriate safeguards were now put in place. One important lesson from this decision is that having policies is not enough. Safeguards must be implemented, they must be monitored, and they have to be enforced in practice. So what are some key takeaways here? This slide kind of summarizes what reasonable safeguards look like in practice. First off, training. Privacy and training should be mandatory and tracked. From an investigations perspective, one of the first things we often ask is, where's your training documentation? We look at whether staff were trained. When were they trained? How were they trained? What did the training cover? We also look at accountability. Annual confidentiality agreements reinforce staff privacy obligations and expectations around access to personal information. They also reinforce that access to personal information is also tied to professional responsibilities and obligations and not just system permissions. Monitoring. Regular audits are one of the most effective ways to detect unauthorized access. In many cases, organizations only discover snooping after a complaint. Proactive auditing helps detect issues earlier. System safeguards. Privacy notices or reminders at login are simple but effective safeguards that serve as an ongoing reminder to staff that access must be work-related and that access may be monitored. And finally, governance. Organizations need strong governance, including regularly reviewing and updating policies and safeguards. Strong privacy governance means privacy is not just an IT issue. It involves management oversight, policy reviews, training, and ongoing monitoring. From the IPC's perspective, at issue is not whether an organization will ever experience a privacy breach. Rather, the key question, especially under Part 10, is whether the organization took reasonable steps to prevent and protect personal information from theft, loss, unauthorized use and disclosure, as well as protecting against unauthorized copying, modification, or disposal. For more information about this particular decision, I would encourage you to visit our website. So in sum, and to close, at the investigation stage, with respect to Part 10, the IPC's role is to investigate the complaints, resolve disputes, promote compliance, and support improved privacy practices across the sector. As we uphold Part 10 to promote the best interests, protection, and well-being of children, in our view, protecting personal information is essential to maintaining public trust in child welfare system, particularly given the sensitivity of the information at issue. Thank you for your time.
Good morning, everybody. My name is Stella Ball. I'm an adjudication manager with the IPC, and I will speak to you today, once I figure out where these mics should go, I will speak to you about the adjudication team's CYFSA decisions. So to date, we have issued 39 actually, because one was just issued yesterday, CYFSA decision 39. The tribunal has issued 39 decisions to date. Most of our CYFSA decisions have addressed the right of access, which I will speak to you about, and 5 have addressed correction of records, and they're listed right there. I have quite a few slides, which, as you know, will be posted, so if I do skip over them because of time constraints, just know that they are available. So who has a right of access? We look to Section 312 for the answer. It's an individual, has a right of access to a record of personal information about that individual that is in a service provider's custody or control, and that relates to the provision of a service to the individual, unless one of the exemptions apply. And in CYFSA Decision 1, which was the first decision to interpret and apply Section 312.1, the IPC said that the interpretation of this section must be guided and informed by the paramount purpose of the CYFSA, which we see in Section 1 of the Act, which is to promote the best interests, protection, and well-being of children. So for the right of access to apply in Section 312.1, we have 4 things we need to consider. The first 3, we'll call them requirements. That's what we usually refer to them as in our decisions. So the first requirement is that it is a record of personal information about the individual requesting it. The second is that the record must be in the service provider's custody or control. And the third is that the record must relate to the provision of a service to that individual. Finally, if all of those conditions are met, we look at the exemptions to see whether any apply. So what is personal information? The first requirement. It is defined in Section 2 of the CYFSA as having the same meaning as in FIPPA, the Freedom of Information and Protection of Privacy Act. And I don't have the whole definition here because it's a long list and it's not a non-exhaustive list. But I have a few for you to think about. Personal information is recorded information about an identifiable individual, including, of course, the individual's age, sex, marital or family status, etc. The second definition, where it says the individual's name where it appears with other personal information, that's paragraph H of the definition, and I refer you to that one because it's kind of a slightly different one because it's a catch-all. So it's the name with other information that may identify the individual, either with the information there or with other information that may be in the record. So think about that one because that's an important one. Remember that if the record is not a record of personal information about the individual requesting it, there's no right of access. So those requirements, all 3 of the requirements that I talked about, each one has to be satisfied, hence requirement. And I'll refer you to CYFSA decisions 4 and 5, where family members, these individuals were relatives of the people who were named and identified and discussed in the records. You'll see our office's treatment of those situations. So Part 10 of the CYFSA allows for substitute decision makers to access records on behalf of the individual for whom they are the SDM. And you can look at CYFSA decisions 4, 13, 22, and 34 for our office's interpretation and application of the substitute decision maker provisions. And those are set out in sections 281, 301, and 303 of the CYFSA. However, note that the SDM provisions do not apply to a request for access to personal information of a deceased individual. I know there was a question about that earlier. I will refer you to CYFSA Decision 13 because there is a full discussion of that issue, and that's where you can find out how our office has addressed that essentially legislative gap. The second requirement, that the record must relate to the provision of a service to the individual, is discussed in a number of our decisions. And what the IPC has found is that it's the children in need of protection and or their families are the recipients of the provision of service. That's set out in CYFSA Decision 1. And you will see that there are 2 definitions of service in the Act. There's a definition at Section 2, Sub 1, at the beginning of the Act, but then which is a long, again, non-exhaustive list. And then at Section 281, which is in Part 10, you have the definition of service, meaning a service or program that is provided or funded under this Act or provided under the authority of a license. So a quite broad definition. There is no provision of a service and no right of access, consequently, under Section 312 Sub 1, if the record does not relate to the provision of a service to the individual requesting the record. So take a look at CYFSA decisions 1, 3, and 5, where our office found that individuals, we'll call them alleged wrongdoers, so 2 teachers and a babysitter, were not provided a service by the service provider. While they were interviewed in relation to a child in need of protection, it was the child and or the child's family who were the recipients of that service, so no access to them. This is not a regime for people who, like the teacher or the babysitter or someone who's been involved in such a situation. It's not an access regime for them. It's not a public access regime. It's specifically for the people who qualify. And then I also refer you to CYFSA Decision 29, where the IPC found that foster parents had no right of access to records, since the records, again, did not relate to the provision of a service to them as foster parents, but rather to the child that they were fostering. So there are 6 exemptions from the right of access, and if one of those apply, there is no access. I won't read all of them because you can have a look at the legislation and they're all set out in this slide. I will note, though, that the exemption at paragraph C is the only one that our office has not yet interpreted and applied. For all of the other ones, there is at least one decision addressing it. So if you're dealing with those, you can look at the following decisions. So starting with the first one at paragraph A, subparagraph 1A, subject to a legal privilege, our office has addressed this in decisions 10 and 37. And what our office has said is that solicitor-client privilege clearly qualifies as a legal privilege under that exemption. For 312.1b, we have CYFSA Decision 37, which found that the YCJA records that were protected under the YCJA were exempt under this exemption of the CYFSA. Then we have the risk of serious harm to the individual or another individual under section 312.1DI. And this one says that if granting access could reasonably be expected to result in a risk of serious harm to the individual or another individual, this exemption applies. And you'll see in 2 of our decisions that address this exemption, 35 and 37, the burden of proof is that the evidence must demonstrate a risk of harm that is well beyond the merely possible or speculative in order to establish that this exemption applies. Moving on to the identification of an individual who is required by law to provide the information in the record to the service provider, I refer you to CYFSA decisions 7, 34, and 37, where the IPC upheld the service provider's decision to withhold information in the records under this exemption, and the information was the name of a referral source, and in those decisions, it was the requirement at section 125 of the CYFSA, the duty to report a child in need of protection if you are an individual who performs a professional or official duty with respect to children. So that's section 312.1DII, that exemption. And then moving on to a similar but slightly different one, 312.1DIII, information that could reasonably be expected to identify an individual who provided information to a service provider in confidence, that's the key, is exempt if the service provider considers it appropriate to keep the identity of the individual confidential. So there's discretion there on the part of the service provider. And you will see that our office in 2 decisions upheld a service provider's decision to withhold, again, the name of a referral source. However, in 3 decisions, we did not uphold it. So have a look at those, decisions 11, 12, and 35, for a discussion of why that exemption claim was not upheld and what the burden of proof is there. So once someone has a right of access, we have to next consider what is the extent of that right of access. And key is the The statement here, the formulation of dedicated primarily to the provision of a service. So the extent of an individual's right depends on whether the record is dedicated primarily to the provision of a service to that individual. We see that qualification at section 312.3. There's the language for it. And an easy formulation that I've given you here is if the record is dedicated primarily to the personal information of the individual requesting it and the provision of a service to them, then the right of access is to the full record. If it's not, then the right of access is only to the personal information that can reasonably be severed from the record. What does that mean in practice? If the record or records relate primarily to the provision of a service to a family of 4, an individual member of that family cannot be said to, does not have full access, a right of access to the full record because the records are not dedicated primarily to that individual. So a really important qualification there. Under sections 317 sub 3 and 4 of the CYFSA, the commissioner has the authority to decide whether to review or not review a complaint. And here is the statutory provision and the various reasons for which the commissioner and the adjudicators as her delegates may decline to conduct a review. There are a few reasons set out. Looking at 4 sub A, for example, the complaint, the person about which the complaint is made has responded adequately. We've used that. Or going back up to subsection 3, there aren't any reasonable grounds to conduct a review. And here are some specific examples. We have, my colleague John mentioned one. That was CYFSA decision 26 that was dealt with at the investigation stage. At adjudication, we've had 4 additional ones. They are decisions 3, 5, 31, and 36. And here's a brief summary of each one and the reason for which no review was conducted in each one of those. So I'll point out, actually, no, I won't point out anything. I'll just let you read that for a second before I move on to the next one. No, I have time. I will point out a couple of things here. So CYFSA decision 3, this was a complaint by a teacher about being denied access to a record. You'll recall I said already this is not, there's no right of access for a teacher who was interviewed as part of an investigation by a Children's Aid Society. And because there's no right of access, and that's what CYFSA Decision 1 said, CYFSA Decision said, we don't need to conduct a review. This is clear. This is what the law says. CYFSA Decision 5, same situation with a babysitter. No review needed. You don't have a right of access, babysitter. CYFSA Decision 30, CYFSA Decision 3, just going back to that for a second, the teacher in that one was requesting a correction of his interview statement. So again, no right of access. That means you also do not have a right to request a correction of a record. So the first step is, do you have a right of access to the record? If so, then you may request a correction of that record. CYFSA Decision 31, there was no review because there was no improper disclosure of personal information, and the service provider responded adequately to the complaint. And finally, CYFSA Decision 36, no review of a complaint by a daycare provider about a denial of her access request because, of course, she had no right of access to request the records. So we have had 5 decisions dealing with the correction of records, and the correction of records is set out at section 315. An individual's right to request the correction of records is limited to records, like I just said, to which the individual has a right of access. You can see CYFSA Decision 3 for a larger discussion of that. And I note that the duty to correct set out at section 315.9 empowers the service provider to decide whether it is satisfied that the record is inaccurate or incomplete. So the statutory provision, 315.9, is set out at the first paragraph in this slide. And it reads as a duty, giving the service provider the discretion to decide. And for a discussion of that, of section 315.9, I refer you to CYFSA decision 24. The duty to correct has two exceptions. The first one is at section 315.10a. If the record was not originally created by the service provider and the service provider does not have sufficient knowledge, expertise, or authority to correct a record, then the service provider does not need to correct the record. So that's the first exception. The second exception at section 315.9b is the professional opinion or observation exception. And the IPC has addressed this exception in two decisions, CYFSA decisions 32 and 33. And the analysis for the application of this exception is, first, you consider whether the information at issue is a professional opinion or observation. And you can look at our correction decisions, specifically 32 and 33, for a discussion of what qualifies as a professional opinion or observation. And then secondly, for your analysis, you're looking at, was it made in good faith? Again, greater discussion of these issues in those two decisions. And I note that there's obviously a common law presumption of good faith and that a service provider can rely on it. The IPC recognizes that. And lastly, the IPC just yesterday published an interpretation bulletin on the correction of records, which we hope you will find helpful in your work. It's available just outside, and it's also available online. And I thank you for your time today. James is back.
I'm back. Thank you, Stella. Okay, great, fantastic. So the next presentation, I'm just going to deal with one court case. We have one case interpreting from the courts that provides some helpful guidance on something that one of my colleagues, Suzanne, was talking about earlier in this presentation, and that relates to cybersecurity incidents. So there are some provisions under Part 10 that set out obligations with respect to unauthorized use, loss, use of personal information, and that's what this case is about. So the name of the case is Halton Children's Aid Society and Ontario Information and Privacy Commissioner. It's a case from Divisional Court. If you're looking for it, it is publicly available on CanLII, which is a free legal reporting service. But just a tip, it's not actually indexed as Halton Children's Aid Society because it was heard together. There were a number of cybersecurity incidents, basically ransomware attacks, that took place across both the child welfare and health sectors. And so the court heard appeals or judicial reviews of a number of these at the same time, and they released one decision which kind of consistently deals with all of them. So you'll find it named as Hospital for Sick Children, but it actually is both cases. And there's the legal citation for those of you who want a quick and easy way to find it. So I'll focus on, of course, the Halton Children's Aid Society portion of this decision. And this was a challenge to a CYFSA decision made by the IPC, and that was Decision 19. The court's case was released in September of 2025. But again, both the CYFSA decision and the related healthcare or health sector decisions dealt with ransomware attacks. So what exactly did happen? There were a number of ransomware attacks. Again, one was on Halton Children's Aid Society. And as a result of those attacks, various individuals' personal information, personal health information in the health sector, but I'm just going to call it PI or personal information for the rest of this talk. Various individuals' personal information was temporarily inaccessible to the various service providers or healthcare custodians on their own servers. And just for some further details, because these kind of matter in terms of the guidance that the court is providing on obligations when you're subject to a cybersecurity incident. While this information was locked down and accessible to the authorized users, i.e. the CAS in this case, or the society, the perpetrators, the attackers, did not actually view, there's no evidence that they viewed, that they accessed, or that they basically removed any of the personal health information. So they locked it down, couldn't get access to it. Now, what's actually legally an issue? What's the issue that we want to know about? Was this an unauthorized use or a loss of personal information under Part 10 of the CYFSA? And if it was, what was the society, was the society required to notify affected individuals under Part 10? So was it a breach? And if so, what are the obligations arising from that? So this is what the CYFSA actually says about that. It does spell out what the obligations are. If personal information is stolen or lost or used or disclosed without authority, then the service provider shall notify the individual and also tell the Information Privacy Commissioner. Now, what the complicating factor here is that neither use or loss are actually defined in Part 10. So you can't do these things, but what does it mean? That was, of course, the crux of the dispute. So what did the IPC find in its decision? Well, we did find that an unauthorized use had occurred. And we found that in the facts of this case, the service provider had failed to comply with the requirement to notify affected individuals. And just note that the language we just looked at said notify affected individuals, and that's going to kind of matter about what that actually means. So the IPC ordered the society to provide the required notice, and they ordered them they could meet that requirement by posting a notice on their website or issuing a public release. And I'll just mention here that our office has taken a kind of contextual approach to what you might have to do to satisfy the obligation to provide individual notice. It doesn't necessarily in all cases mean providing individual letters to each individual, and that is a contextual approach. It does depend on various factors. So in this case, I explained that the servers had been locked down, but they hadn't actually taken the information out, they hadn't used it. So we looked at those factors and determined in this case the requirement for notice could be satisfied by posting on the website or a public release rather than mailing out however many letters. But that could change, so that depends on the circumstances. If it had been a serious breach, not to suggest it wasn't serious, then there might be additional notice requirements to meet that obligation. Okay, so that's what we said. What did the court say? The court said, look, when you're interpreting these provisions, look at text, look at context, look at purpose. They usually say this. It's the contextual reading of the obligations. And they agreed with the IPC that a ransomware attack that successfully encrypted, the term they used was containers, containing personal information is an unauthorized use. So what's helpful about this in terms of going forward is a use under the Act can occur without direct interaction with the information. As I said, there's lots of things they didn't do to it, but this satisfied the sort of scope of being a use, just locking it down. And what did they say about notification? So there's a lot here from the court. They said, one of the important things they said was the obligation to provide notification does not depend on there being a risk of harm to an individual before notification is required. And this is, some statutes, some privacy legislation talk about a real risk of serious harm. Earlier I talked about this other new law that requires notification where there's been a cybersecurity incident, and that does have risk of harm criteria. But under the CYFSA, there's nothing in there that talks about risk of harm, and the court agreed it's not there, so you don't need it. And they talked about why it still may be important to provide notice even when we haven't established in the evidence a risk of harm. And that includes things like holding the custodians of the personal information accountable for the measures they've taken, going back to what we talked about earlier, the measures they've taken to protect individuals' personal information. So this is about a sort of a broader accountability in terms of protection of that information. So what are the key takeaways here? A cyber attack that encrypts containers, that's a crazy term, but basically servers housing personal information is a use of that personal information. Notification to individuals is not subject to a risk-based threshold. You just have to establish that there's been an unauthorized use or loss. And a cyber attack that triggers the duty to notify will arise whether or not further malicious action has taken place. So as in, like, you don't need to establish that personal information was stolen, that it was put on the dark web, but or that a ransom was required. You just have to establish that there's been an unauthorized use, and then the obligation to notify kicks in. So those are my key takeaways, and phew, we have some time for questions and answers. I don't know how those work, so I'm going to go back over there. Thank you.
Yeah, thank you very much. So as per before, the mics on the table are live. You guys can address the questions as they come in. So we have a roving mic in the room if you put up your hand. Otherwise, we also have the Slido for folks here and online. I'll turn it over to our question moderators.
All right. How does access to records apply to First Nations? Do they have a right to access?
Is this on? Is this live? Sorry, can you hear me? Yes, okay. I see a lot of faces looking at me, so I'm going to try to answer that, and with apologies for probably not providing a great answer. I think there's a couple, again, I'm just going to say, I think there may be a couple layers to this question. One is, Part 10 itself provides individual rights of access, and so that's what Part 10 does. And my colleague Stella talked about there being various criteria that have to be fulfilled to meet those. You have to actually be in receipt of a service, and then the right of access kicks in, and there's some other conditions. So that doesn't really anticipate a right of access by a First Nation or any other kind of collective body or organization, certainly not other organizations. And I know that there are some access challenges that we've heard about from First Nations, particularly those who are looking at taking up the ability to exercise their rights with respect to governance of child and family well-being activities, so they're looking to get a sense. Sometimes I understand they're looking to get access to information so they can assess whether they should assume those responsibilities or obligations or duties. That's probably not the right word, but assume that jurisdiction. And in other cases, when they are doing so, also, of course, getting access to those records so they can kind of effectively do that when they've made that decision to exercise their jurisdiction. So I think my own view is, again, this is a personal view, is that Part 10 does not really clearly anticipate how this is going to happen. And that's unfortunate. There are various arguments about how there may be rights of access, but I think there's still there's a huge lack of clarity about how those rights can be exercised, how that takes place. Part 10 itself doesn't clearly address that, I think. I think that's fair to say. I think it's very much focused on individual rights of access. And I'm not going to say that there aren't. There isn't the ability to share that information, but I think there's a real lack of clarity. So that's something that is going to continue, I think. Hopefully, we'll have more clarity in the future. Maybe there'll be clarity from the ministry. Maybe they'll release guidelines on what their understanding of it is, or there may be legislative changes. I'm totally speculating here. There may be none. I have no idea if there will be. But I think it's a gap, right? That, to me, it is a gap right now. That's all I have to say on that, unfortunately.
All right, if there are no questions in the room, the next question is, when there's no custody order and parents are separated or apart, is consent required from both parents for the children's records?
I'm going to jump on that again. So we do actually have a decision, I think it's decision 22, is that right, Stella? Decision 22? Sorry to put you on the spot. I'm pretty sure it's decision 22. We have a decision that does speak to joint custodial parents. That may not be exactly the question here, but there is a decision that has looked at that recently when there's no custody order and parents are separated. So essentially, I mean, probably yes, consent is probably required from both parents in those circumstances. I mean, typically, you can be the substitute decision maker, you can exercise your rights to access on behalf of the child if you're the custodial parent. So if it's a situation where there's joint custody, then you need both. The only reason I'm being a little wishy-washy here is just for the way the question is, maybe there's a lack of clarity. If there's a lack of clarity who the custodial parent is, then I think you got to figure that out in order to answer the question. But if there's joint custody, you do need both. Now, I would also just say that there are other provisions of Part 10 that allow for disclosure in certain circumstances, and those include in relation to risk of harm. So a society who can exercise their discretion where appropriate and where it meets that threshold to provide information under the risk of harm criteria. So that's another basis. Of course, and the decision I referenced before, again, I think it's 22, but whatever it is, that had been looked at by the society, and it was considered by our office when the challenge to that access decision came to us for review. And in that case, both the society and our office was satisfied that that had been considered, and on the evidence, there was no evidence in that case that there was an obligation or even discretion to disclose under the risk of harm criteria. So that wasn't engaged in that case. Now, in another case, it might be, and that might provide a different basis for disclosure, again, where you might not have to meet the joint custodial parent rule for everyone consenting. Hope that helps.
Just to add, I know we've said it before, but all of these decisions and all of these assessments are case and fact specific. They're record specific. So in this question, I'm not sure, it's not clear to me what the status of the parents is, if there's no joint custodial order or, but regardless, whatever the situation is, we're assessing it as service providers are based on the facts, applying the legislation to the facts. So you would look at the act and figure out the status of the parent or parents requesting access and go from there.
All right. How do you know for sure if the ransomware attack did or did not involve using or looking at the files? What protections are in place to ensure that the data is not stolen in this case?
I'm only going to jump in here this is not my area of expertise, so anyone else who wants to jump in can, but typically with these things, they're established on the evidence that's available. That might include an audit by the service provider. I would think it probably would, perhaps calling in, if they don't have in-house resources, other experts who can assess exactly these questions. So in the case I talked about earlier, there was evidence exactly about what had been accessed, what hadn't been accessed, sort of a forensic, I don't know if that was a forensic audit, but something along those lines that can actually establish factually what's happening in each case. And so, of course, that's going to vary.
Yeah, I would add that we do look for evidence to show that that's actually the case, and if we don't see it, then that would be something that we would we would ask for more information on in a review of that.
Okay, time for one more. Wrap it up. Okay, wrap it up. Okay, thanks.
Yeah, thank you very much to our panelists, and thanks for your questions. We are at lunch. I do want to say all our panelists from this morning are here, so if you do have questions, please reach out to them. We're more than happy to answer them, and then obviously we'll put questions in the queue for this afternoon. One thing I wanted to do just before we broke for lunch is we showed a couple videos during the break, which folks online had seen. I thought we'd show them here in plenary, and then we'll break for lunch. I'll be back in 1 sec, just 2 short videos.
Access to government information is essential to a healthy democracy. It provides a window into government decision-making. It supports accountability and transparency. It fosters civic engagement. But if you've never filed a request before, the process may seem a little daunting. So here are a few tips. 1. Think about which government department may have the information you want. 2. Use the access request form available on government websites. Filling it out and submitting it is quite straightforward. 3. If you're not sure how to phrase a request, ask the institution. They have an obligation to help you. 4. Be as specific as you can. It'll help make the process more efficient. 5. You can file an appeal with the Information and Privacy Commissioner of Ontario if you believe your access rights have been denied. To learn more about access to information rights under Ontario's laws, visit ipc.on.ca. More and more, we are living our lives online and using technology in all kinds of helpful and innovative ways. Organizations collecting personal information need to follow certain rules to protect data, but individuals also have a role to play. How can you get the most out of the online world and protect your privacy? Here are 5 tips. 1. Look into what a company does with your information before choosing to download an app. 2. When available, use multi-factor authentication to access your online accounts. This means using more than just a username and password, like a special access code sent to your smartphone. 3. Tighten up those privacy settings. Don't just stick with the defaults you're given. 4. Think before you share something about yourself or someone else on social media. 5. Push back on companies that ask for too much personal information. Limit what you share to only what's necessary to get the product or service you want. You know, there are lots more ways to be privacy aware. For tips to protect privacy and to learn more about your rights under Ontario's privacy laws, visit ipc.on.ca.
Awesome, thank you. I also just want to point out, we have Chris Parsons, our Director of Tech Policy here, since there were some questions on cybersecurity and ransomware attacks, so feel free to pick Chris's brain as well. Big round of applause as we wrap up the morning. All right, we've filled your brains. It's time to fill your bellies. So we're going to convene for lunch. It'll be right outside, and we'll start back up at 1 o'clock. Thank you much. Thank you very much, everybody.
fire from the gods. This is when you dance all cheeky. Give me sugar, give me honey. This is when you dance all cheeky. said, be honest with how you feel. I said, that's easier said than done. I said, don't worry about the future. She said, that's easier said than done. Well, it is. 'Cause true love, it ain't easy, no. She said, just show me this love is real. I said, that's easier said than done. I said, just trust the way you feel. She said, that's easier said than done. Well, it is. 'Cause true love, it ain't easy, no. True love, it's worth it in the end. Yes, it is. True love, it's worth it in the end. Yes, it is. True love, it's worth it in the end. Worth it, darling. True love, it's worth it in the end. Ooh, it's easier said than done. Ooh, it's easier said than done. Well, it is. 'Cause true love, it ain't easy, no. No, no. True love, it ain't easy. True love, it ain't easy. It ain't easy.
It was right there in front of me, screaming loud. I didn't wanna see. He scooped his eyes, glanced down on me, trying to use me up, but I never had a Midas touch. You wanna chew me up, but I never get a loose
down before you hit the ground. Sort it out before you twist it out. Sick and tired of messing around. Light up the gateway to play around. Money ain't no good to me. Money ain't no good to me. Ooh, yeah. Money ain't no good to me. Money ain't no good to me. Ooh, yeah. Hold it down before you breathe it out. Stack it up before you lose your touch. Sick and tired of messing around. Light up the gateway to play around. Sick and tired of messing around. Light up the gateway to play around. Money ain't no good to me. Money ain't no good to me. Ooh, yeah. Money ain't no good to me. Money ain't no good to me. Ooh, yeah. education, but I can see right through a powdered face on a painted fool. Let me slip through. Why you tryna hold me back? I'm just tryna move up front, little more this, little less of that. Feel me? Let me come through. I'm tired of being in the back. I'm just tryna move up front, little more this, little less of that, yeah. They tell me I was born to lose, but I made a good thing out of bad news. Don't worry about people in my face. I hit them with the style and grace, and watch the ankles break. Whoa, whoa. I know you wish I would fade away, but I got more to say. Lord, they pray. Ow! Let me slip through. Why you tryna hold me back? I'm just tryna move up front.
All right, we're going to get started in about 3-4 minutes. If you want to grab your lunch, finish, feel free to keep eating, but grab whatever you want, and we'll get underway in a few minutes. Thanks. Okay, we're going to get back underway. I hope everyone enjoyed those lovely lunches. And just to kind of get us back into the groove, we're going to start the show just as folks are getting settled, and we'll jump into the proceedings.
Phishing is a way that hackers can attack computer systems. The attacker sends a message that tricks the recipient into revealing sensitive business and personal information or downloading malware. Here are 5 tips for avoiding a phishing attack. 1. Be wary of emails from someone you don't know, asking you to do something urgent. 2. Examine the from address or the date and timestamp for anything that seems off. 3. Never open suspicious file attachments or click on suspicious links. 4. Look for typos that you would never see from reputable institutions or businesses. 5. Ensure your computer has security software installed. You know, there are lots more ways to be privacy aware. Check out our tips and other resources at ipc.on.ca.
Great, thank you. So now, perfect segue, we're going to bring up Karishma Ferdowsi, our Senior Policy Advisor, and Miranda Clark, who you'll recall from this morning, our Senior Policy Advisor, to talk about some of the resources we have at the IPC, which I think you'll find very useful. As part of that, come on up. As part of that, we've got another poll question, which is poll question number 3. Which statement best reflects your organization's current approach to privacy risks? We are primarily reactive, responding as issues arise. We are strengthening policies and governance. We are integrating privacy by design into programs. We are proactively identifying and mitigating risks, or you're unsure. So take a few minutes to respond to that poll question. I like that one. 100%. It's holding. Okay. Okay. Reality's kicking in. Okay. All right. So right now we are strengthening policy. We are proactively identifying and mitigating risks, primarily reactive. We are strengthening our policies and governance, and we're integrating privacy by design, and a few folks unsure. So you can keep voting. Thanks for that. It's very helpful. I'm going to hand it over to Miranda to get us underway. Thanks.
Okay. I'm not as tall as Mike. Okay, hello everyone, me again. In this presentation, we're going to explore the IPC's guidance materials and resources, which have been developed to help service providers understand their obligations under Part 10, and for service recipients to understand their privacy and access rights when receiving services under the CYFSA. Okay, so the IPC's Guide to Access and Privacy for Service Providers was released just before Part 10 of the CYFSA came into force to support service providers to understand their obligations under Part 10. It provides an overview of the core rules for collecting, using, disclosing, safeguarding, and managing personal information. It discusses consent and capacity and access to and correction of personal information, and it also explains how these rules are enforced and provides an overview of the role of our office. We will be considering what updates may be needed to this guidance with the introduction of the new use and disclosure restrictions that we talked about this morning, so stay tuned. So the IPC's Guide to Providing Access to Personal Information was created to help service providers understand their legal obligation to provide access to personal information under Part 10. It is aimed at staff who receive and process access requests. Part 1 of this guide explains an individual's right of access while also explaining the exceptions to that right. And Part 2 of the guide explains requirements and best practices for how to process access requests, including how to clarify and narrow a request, conduct a search for records, and respond within set timelines. This guide also includes a helpful checklist for responding to access requests. So if you haven't already, check it out. Okay, so Stella mentioned this morning about interpretation bulletins. So to give you a little bit more information about what an interpretation bulletin is, the IPC's interpretation bulletins compile almost everything you need to know about a particular section of Ontario's privacy laws. They support our goal to address our tribunal's function in a fair, timely, and meaningful manner by enhancing understanding of the law and our tribunal processes through education and actionable guidance. Interpretation bulletins outline the purpose of a specific provision, explain key terms, lay out established tests, and important considerations for applying the provision, and include links to some of the most important and relevant IPC decisions for handy reference. We update interpretation bulletins when landmark decisions are released. By flipping the script to make these materials proactively available as interpretation bulletins, service providers have easy access to resources that can help them make thoughtful and well-informed decisions on their privacy obligations under Part 10. They are also invaluable for training new staff, explaining complex matters to your organization and decision makers, and supporting conversations with requesters. Importantly, for all of us, they help parties understand earlier in the request or complaint process what to expect, which can help prevent lengthy disputes. In March, which is just yesterday, we released our interpretation bulletin under Part 10, focused on correction to records. This interpretation bulletin outlines the factors for determining whether an individual's request to correct a record of personal information held by a service provider may be granted under Section 315. This bulletin explains who may request a correction to a record, when a service provider has a duty to correct, and exceptions to the duty to correct. This is the first of many CYFSA specific interpretation bulletins to come, so be sure to check out our website on an ongoing basis for this bulletin and others. And there are also printed copies of the bulletin at our info booth that you can pick up today. Okay, the IPC also has guidelines for service providers for reporting a privacy breach and submitting annual statistics to the IPC. These guidelines include information about situations where service providers must notify the IPC of a privacy breach, how to report a privacy breach to the IPC, and how to track and submit annual statistics to our office. The annual statistics reporting deadline was also yesterday, March 31st, for data collected from January to December of the previous year. In reporting your stats, you probably noticed or may have heard that we have a brand new online portal for submitting your annual statistics. The new portal has enhanced security features designed to protect data integrity and accuracy, and is intended to be a lot more user-friendly. If you have any questions about stats reporting or the new portal, please reach out to us. Okay, on our website, we also have a dedicated page which features Part 10 of the CYFSA Frequently Asked Questions. Here you will find responses to questions about privacy, access and correction, and consent and capacity for both service recipients and service providers. So if you haven't checked those out already, we encourage you to do so. Okay, and then yes, you can. So common misunderstandings about privacy are frequently cited as reasons for not sharing information with a Children's Aid Society about a child who may be at risk of harm. In 2016, the IPC and the formal Provincial Advocate for Children and Youth created the Yes You Can guidance to help professionals understand that privacy is not a barrier to disclosing information to protect a child from potential harm. This guidance was updated in 2018 to align with changes to the CYFSA, and now, in collaboration with the Office of the Ombudsman of Ontario, we are again updating this guidance in response to a death review conducted by the Child and Youth Death Review and Analysis Unit at the Office of the Chief Coroner. The key objective of these updates is to reflect current laws and regulations, such as the enactment of Part 10 of the CYFSA, and to further emphasize and clarify the ongoing duty to report and voluntary reporting for youth aged 16 and 17. We would like to take this opportunity to thank the Ontario Association of Children's Aid Societies, the Association of Native Child and Family Service Agencies of Ontario, and the Ministry for consulting with us on these important updates. We are planning to release the updated version very soon, so stay tuned. Now I'm going to pass it over to Krishma.
Thanks, Miranda. Hi, everyone. Oh, that's great. Okay, so hi, everyone. My name is Krishma Ferdowsi. I'm also a Senior Policy Advisor at the IPC. So I'll just be following along the conversation that Miranda just shared around some of our additional resources and IPC guidance. So the first one here is, in May 2024, the IPC published Sharing Information in Situations Involving Intimate Partner Violence, Guidance for Professionals. So this guidance was released in response to Recommendation 78 from the Office of the Chief Coroner's 2022 inquest into the tragic deaths of 3 women in Renfrew County due to intimate partner violence. So the inquest jury, which compiled of 5 community members from Renfrew, called on the IPC to develop guidance to empower IPV professionals to make informed decisions about privacy, confidentiality, and public safety. So of course, we readily accepted the recommendation and began extensively consulting with 22 organizations across the justice, health, and social services sectors. We also did a targeted focus group with survivors of intimate partner violence in order to understand and reflect their experiences navigating across different systems that impact their privacy and access to information rights. And those insights were then used to inform our IPV guidance. So of particular note to this sector in particular, we did consult with the child welfare sector, of course, and this included the OACAS, ANAFCIO, and also the Ministry MCCSS. Perfect. So the outcome of that consultation was plain language guidance that helps support professionals' decision-making in situations where there's a risk of serious harm to an individual's health or safety. Particularly with this guidance, it was, of course, in the context of intimate partner violence, to be responsive to the coroner's recommendation from the jury targeted to our office. So since it's released almost 2 years ago, 2024, we've received a lot of positive feedback on the guidance. We've been out across the different sectors talking about the guidance, getting a lot of feedback in terms of how it's actually being operationalized within situation tables, policies, and procedures. So if you haven't already, we certainly encourage you to take a read and give us your thoughts after the fact as well, after you've done reading it. Another thing that's quite nice about this guidance is that it's not just for the child welfare sector. We have included it to include a scope that cuts across both the justice and the health sector. So it helps different sectors understand how other sectors may be disclosing information when there is in fact a risk of serious harm. As well as the guidance goes beyond a risk of serious harm disclosure, it does talk about other permissible provisions like, of course, consent-based disclosures. So, of course, please be sure to come say hi at our booth and take a physical copy. If you're online, no worries. You can also find a digital copy of our guidance online, as well as the other ones that Miranda and I are referencing today. Perfect. Okay. So our office is also currently updating our new disclosure in emergency circumstances fact sheet, which was actually originally published all the way in 2005. So this new quick guide will be called Sharing Information in Situations Involving Serious Harm. So these updates are consistent with our Yes You Can updates, which, like Miranda said, is going to be responsive to a CYFSA recommendation that we received last year from the coroner's office. So this quick guide follows closely our IPV guidance. It takes the wealth of knowledge that we gained across the different sectors and applies it to a broader scope of information disclosures, particularly in any circumstances that may be deemed a risk of serious harm. So I think you can clearly see here from the guidance we're talking about today is that we really want to emphasize from the regulator's perspective that privacy is not and should not be seen as a barrier to disclose the lawful and responsible sharing of vital and in some cases life-saving information when an individual's life, health, or safety is at harm. So this updated guide, along with our Yes You Can guide, is set for release shortly, so please be on the lookout. Alrighty, so another helpful guide that we want to highlight today is about It's About You pamphlet. So this pamphlet's actually quite great because you can actually use it to share with your service recipients to help support their understandings of rights under the CYFSA. So this pamphlet is written in a plain language FAQ format. It walks those interacting with the child welfare sector on certain obligations service providers have under Part 10. So this, for example, will include required notifications around how personal information will be used, how information could be disclosed, how information must, of course, be kept confidential and secure, breach notifications, and among other things. This material might also be helpful, of course, when James was talking about your new requirements to display information about rights under Part 10. So again, we do in fact encourage you to visit our booth outside for more information and other helpful resources that will support your obligations and understandings for both you as a service provider and as well as your service recipients. So, perfect. So in addition to our guidance, many of you already know, but Commissioner Kasim hosts an award-winning Info Matters podcast. So over 4 seasons, Commissioner Kasim has spoken about a broad spectrum of transparency and privacy matters with people from all walks of life. So this includes youth, IPC staff, child welfare professionals, tech billionaires, medical researchers, and many more. So there's a lot of great episodes that we do encourage you to check out, but the ones directly relevant that we wanted to highlight today are Season 1, so First Nations Data Sovereignty with Dr. Jonathan Dewar and Carmen Jones. Season 2, Giving Foster Kids a Fair Shot in Life with Jane Kovarikova. And finally, as well, Season 2, Episode 8, Seeing Privacy Through an Equity Lens in the Child Welfare Sector with Nicole Bonney. We also have a lot of other really interesting episodes on things that are certainly relevant to the sector as well, more broadly around children's privacy, education technology, which may of course be of interest given EdSTAR regulations, and also things like situation tables as well. So again, you can find our episodes wherever you get your podcasts, so on our website, on Apple, Spotify, etc. So key takeaways. So of course, we are coming to a close on our policy and resources session. But before we do, in fact, jump into the Q&A, we just want to summarize 4 key takeaways that we want you to walk away from after this particular session. So first, the IPC has several helpful policy guidance and resources that help support the child welfare sector understand their obligations under Part 10. We have a new interpretation bulletin on correction to records, which we do, in fact, of course, encourage you to look at. If you're a podcast person like us, we have great Info Matter podcast episodes available online for your sector and more broadly as well. And lastly, we have updated guidance coming out soon. Yes, you can, and our quick guide. So please be on the lookout for any of our communications on our websites as well. It's really exciting to be able to unveil these 2 new guidance materials for your sector. So be on the lookout. Alrighty, let's jump into Q&As then. Thanks. I think so.
So we haven't received any questions so far in relation to our guidance, so please pop them into the Slido. Now is a great time. And perhaps there's some questions in the room. Just putting it out to anybody in the room who might have a question.
Oh, we do have a question. Thank you very much, Lorraine.
Needs to be in caregivers' homes. To look at your brochure yet, but have you received the draft poster template that the ministry is proposing, used by members? Meet their agency's needs. Service models, only in that I just don't document and the ministry's document are going down the
Answer that. So the It's About You pamphlet is actually from originally when Part 10 came out. So it's not new requirements, but Krishma did mention that it may be helpful. Await for further guidance and materials to come from the ministry. That's their responsibility to provide those operational materials. So we are just simply suggesting that this might also additionally materials from the ministry.
Excellent question. Anything coming online? No worries. Before I in the back, we do have one more poll question directly related to your presentation.
Okay.
Which IPC resource are you most likely to use or revisit after today? So we have a lengthy list there: the CYFSA Interpretation Bulletin, the soon-to-be updated Yes You Can booklet and guidance on sharing information in emergency situations, sharing information in situations involving IPV, Part 10 Guide to Access and Privacy, It's About You brochure, Privacy Breach Reporting Guidance, or the Annual Statistics Reporting Guidance.
And while we wait for those answers to come in,
Yeah,
we did get a late breaking question.
Go right ahead.
Are there other interpretation bulletins in the works for the CYFSA?
No, not yet. It would be a question, I guess, for our tribunal. I don't believe there's any going yet, but we, this was the one that we released is the first one in, like I said, what we expect to be a series of bulletins. There's a number of bulletins for PHIPAA and MFIPA, so I don't believe there's any in the works, but I think we should see more and more coming soon.
Awesome, thank you. Well, a clear winner in the poll, CYFSA interpretation bulletins with over half
Yeah, that's great.
the votes.
Obviously,
Yes.
we're on the right track with getting some of those for this sector.
Awesome. Well, thank you very much. A round of applause for Miranda and Krishma. Thank you. And now we're going to shift to our much anticipated panel. So I would ask panel members to come on up. Feel free to come on up and get settled. And just a reminder, we're going to be taking questions of the panel at the end, so feel free to hop in and get your questions in early into the queue. Really looking forward to hearing some of the experiences, challenges, and practical solutions from our panelists. Do want to briefly introduce Solomon Owu, who's going to be our moderator for the panel. Solomon is the Chief Executive Officer of the Ontario Association of Children's Aid Societies. Thank you very much, Solomon, for agreeing to moderate the panel. Solomon has more than 20 years of international experience across healthcare, government, and children's services. He's led major initiatives, including the Child Welfare Funding Formula and the Child Protection Information Network, as well as projects in financial planning, governance, capital management, and organizational restructuring. So with that, a big round of applause for the panel.
Thank
and I'll
you,
hand
Michael.
it over to you, Solomon.
Thank you. Good afternoon to everyone here today. I had much anticipated, so the pressure is on. So let's get into it right away. I'm going to start off with a quick introduction of my panel. And the good thing about being a moderator is you don't have to answer any of the questions. So I have experts here, and they are going to try and get us into some insights and some of the impacts of Part 10. So starting off, I have, I'll start with Jody, since you are next to me. Jody Potts is a supervisor of service relations and privacy program at Durham CAS. Jody works with frontline staff, leadership, and legal counsel to embed privacy by design principles within the organization, as well as Part 10 of the CYFSA. She recently partnered with York Children's Aid Society to host the annual Privacy Symposium for Ontario Child Welfare. She is focused on building a strong culture of privacy in child welfare through education, real-world examples, risk-based decision-making that supports both accountability and innovation. Thank you for joining us, Jody. Moving on, I'll go to Max. Max Behrens is a third-year student at King's University College at Western University, pursuing an honors specialization, bachelor degree of childhood and youth studies. Max is also a leader on the Youth Provincial Advisory Committee through the Ontario Association of Children's Aid Societies and has recently started working as an inclusion counselor for the Boys and Girls Club in their city. Having a passion for youth in care, Max is devoted to sharing experiences and helping to advocate and facilitate better services to all youth. Thank you for joining us, Max. Michael. Michael Miller is the Executive Director for the Association of Native Child and Family Services of Ontario, and is also a member of the IPC Strategic Advisory Council. Michael is an OG Cree from Matagami First Nation in Treaty 9 territory and has a career spanning 25 years focusing on social development of Indigenous communities. He has served as the Executive Director of Aboriginal Legal Services in Toronto And prior to that, he served as a housing director for Cochrane District Social Services Administrative Board. He also served as the executive director at Kunu Wanimanu Child and Family Services in Timmins and has led the agency to become a mandated children's aid society. Thank you for joining us, Michael. And the last but not the least is the lawyer on the team, Alison Munsi Mohan. Alison is the Director of Legal Services and Senior Counsel at York Regional Children's Aid Society, where she shapes the organization's legal strategies. Alison has 26 years of legal experience, with 18 years of those in child welfare. She serves as a co-chair for the Senior Counsel Network Group at Ontario Association of Children's Aid Societies. Beyond her professional role, Alison has served as a vice president of the York Region Law Society and chaired both the Diversity, Equity, and Inclusion Committees, as well as the Employee Relations Committee. Thank you, Alison. Well, I guess the panel is ready, so we want to get right into the business of the day. Let me start with a quick question for three of you. Start from an organization level. In the sense that with Part 10 coming into play, what has changed, what are some of the changes you've seen most in your organizations to be able to implement Part 10 in terms of the collection, use, and disclosure of information? So maybe Jody, you want to kick us off with that?
Sure, I'd love to. It's great to be here. I need a microphone.
Yes.
Do I need to do anything? Okay. Yeah, absolutely. So I like this question because it's obviously where we're at. I think the most obvious answer is access to information requests. We have the statistics that need to be submitted annually, and it's kind of in your face. The volume has been going up and up and up since 2020. I know at Durham Children's Aid, we completed over 1,000 access to information requests last year, just access information requests. On top of that, of course, disclosure, records requests, all those types of pieces. And I think that's kind of the most obvious change that's happened, but I think that's happened for a reason. Also, we're letting service recipients know of their rights, and I think that information and word is getting out there, probably what Part 10 intended in the first place, so I think that's a great sign. But of course, what goes along with that is the resources that go into other areas, the record corrections, we've just been talking about that as well, and the time and energy that goes into the complaints and breaches, they all kind of go hand in hand. And I would say, I think what's a little less visible, perhaps, is the culture shift that is starting to happen. It's going on 5, 6 years now, and privacy is no longer just a theory. So we have dedicated teams. A&D, we affectionately call our Access to Information and Disclosure team, and they work really hard. They read files and provide those records day in and day out. And I think that's really valuable because they get to see where our strengths are, but also where there's some gaps, and we get to use that information and fine-tune it and then grow and develop from there. So, for example, just recently we had, from what they were seeing and sharing, we decided to roll agency training on collection, and that further kind of embedded that culture shift, we hope. Still playing it, but yeah.
No, thank you on that. And so, Max, I'll come to you in a minute, but as I talk through organizational structures, Michael, you lead the indigenous agencies across the province. So from your perspective, what has changed or what organizational pieces have had to happen to embed Part 10 of the CYFSA?
All right. So Part 10 actually years ago was actually the law that, or the section of CYFSA that actually enabled indigenous agencies to become a mandated agency. So that Part 10 for us was actually the development of indigenous child wellbeing agencies prior to it being replaced with data. So the one key thing here is, again, with for us as an association, again, we don't collect personal data or information in that respect, but we do have our support networks. Again, Lorraine and some of our policy analysts, again, help support the quality assurance, the data departments in our respective agencies. Because again, one of the key things there is, again, the legislation provides a framework. Ultimately, it doesn't, each specific scenario, as you guys heard earlier, there's different situations in terms of when it's appropriate to share that type of information. But one of the key things, again, dealing with our First Nations and our agencies, is that, along with CYFSA, there's also C-92, that, again, the federal act, that, it is, again, a pathway to actually create First Nation laws, but it's also, again, set some standards there in terms of notices and, again, providing that information in there. So, again, Section 12 and also best interest of the child kind of speaks to that. So, again, a lot of our agencies have always, shared that information with the respective First Nations. But again, now with Part 10, it provides some clarity around there in terms of what can be shared with that. So many of our, again, agencies come together and, they work with the respective, now there's actually funding for what we used to call band reps or First Nations representatives. So again, that importance of coming together and sharing that information, because again, some of the First Nations now, you've probably heard on Monday, there's the Ontario Final Settlement Agreement that was approved by the tribunal, and that is actually starting to come as well, going to be implemented in the next coming years, or in the next year with that. So again, the challenge is there is, again, working with some of their prevention programs, their post-majority care programs. So again, that's vital to share some of that information back to the, again, either children aging out of care, what type of supports were they accessing before, and what new ones are potentially available to them as well. So again, it's that holistic approach that many of our First Nations and ultimately our agencies' service models have always spoken to as well, and that, we need the appropriate amount people at the table to make those critical decisions when it comes to protecting children. So that has been, again, I guess, an evolution and ultimately within the legislation too. So.
Thank you, Michael. Alison, any more structural changes from an organization perspective you want to touch?
Yes, Solomon. I would say the most significant change brought about by Part 10 is not simply technical compliance with a standalone statute, but we've had to make a cultural and operational shift in how we, as the sector, think about personal information as a core child protection issue, as opposed to an administrative afterthought. So privacy has become, for us in our sector, a leadership governance issue. It's a legal risk issue. I mean, think about regulatory scrutiny, IPC investigations, and it's a service delivery issue, right? Information flows impact families, children, outcomes. So 6 years in, we have seen a philosophical shift in the sector. So I would say our sector recognizes that privacy protection is not in tension with child protection, but it is a fundamental part of it. We have had to reconcile our protective mandate with the reality that information itself can cause harm if misused, even when our intentions are good. So Part 10 has accelerated for us a move from individual worker responsibility to organizational accountability. Part 10 has changed the tone of our relationship with children, youth, and families as they are rights holders within a regulated information system. And for us, privacy breaches are no longer seen as isolated mistakes by individual staff, but we understand them as systems failures that demand root cause analysis. So in short, what has changed the most is not simply what we're allowed to do with information, but how carefully, consciously, and defensively we must do it.
So Alison, just as you were talking, you mentioned a couple of things that I want to bring Max into the conversation here. You said privacy is a core child protection issue, as well as you mentioned that information can cause harm if misused. So Max, from your perspective, how do young people feel about their information being collected, used, and shared by others, even with the intention that it is being collected for service delivery?
Well, I can't speak for all youth, but I think that young people are concerned for their well-being because they understand the technologies around them and that the security of their information can be compromised. And I'm so glad that this was talked about earlier because that makes this example not so far-fetched. But more and more young people see this happen all the time. The United Convention on the Rights of the Child, or the UNCRC, Article 16 shares that children have the right to protection of privacy, and that means that adults need to ensure that children's privacy, home, and identity are kept from attacks or abuse of their information. In my personal experience, information is a precious thing that is very fragile, and I learned that through growing up with unrestricted internet access, and that information can be taken without you knowing in a matter of seconds. Having our personal information shared and used can potentially breach confidentiality, as well as the trust that we put in to give said information. We feel that it is important to use extreme caution when giving other organizations our information, as an adult may not know what a young person wishes to share or doesn't wish to share. Think about that for a moment. How would you feel if your boss gave your information to a psychiatrist without talking to you first? They could have given any reason, and that would leave you in a panic, maybe annoyed, maybe even angry. And because you weren't asked nor got to give your expression, we are the same way, and it's important to talk first and foremost to figure out those boundaries.
Thank you, Max. And as you were talking a couple of times, I had consent without using the word consent. So I'm going to come back to you with a question on consent. But before then, Michael, let me take you to a place of challenges. As with most legislation or new ways of doing things, potentially you expect some challenges across the path. So from the perspective of First Nations, families and children and well-being agencies, what unique considerations or challenges have arisen with the implementation or application of Part 10?
So again, one of the issues that I kind of alluded to earlier is that it's not only just Part 10, unfortunately, that affects our First Nations. There's a, C-92, the federal law, UNDRIP. Again, we're currently, and even if you look at the TRC, the first 5 calls to action are specific to child welfare. And it was intentionally, the Honorable Marie Sinclair put those there intentionally because, again, unfortunately, today's child welfare is the modern day residential school. And we need to show, we need to share a lot of information with our respective agency, our First Nations as well. So the complexities there that there's, First Nations are also a federal responsibility in terms of fiduciary responsibilities in terms of federal government. But also, again, as I mentioned, they underfunded a lot of our, and were discriminatory against our First Nations child welfare services providers. And again, under CYFSA, though, it talks about the disclosure of information and the need to provide consultations, consent under Section 72 and 73 of the CYFSA. But again, that's just not in isolation as well, because again, there's, like I mentioned, there's other federal legislation that also takes into account the proper notices. So one of the cases that actually went to court with Linked Child, Youth and Family Supports versus Walpole Island, that was one of the considerations that when the court made their decision is that, they not only took CYFSA into account, but they also took in UNDRIP, C-92, and again, the calls to action, all these types of things in ensuring that, again, that proper information is being shared with the First Nations. Because again, under CYFSA, there's special provisions in which certain services can be provided to their community members, such as customary care is one of the big ones. But again, that's again a part of their rights in terms of ensuring that they take care of their own children. So, now there's also seen steady funding for First Nations representatives. In years past, that unfortunately wasn't there as well. Notices were basically a simple fax way back when. Nowadays, I guess it's an email potentially. But again, that's unfortunately the extent of notices. So again, that meaningful consultation is now required. And again, sharing that information. So one of the things, again, a lot of our First Nations and agencies are starting to see is the development of protocols and how they work together and how they share information as well. So those, again, are trying to break down those barriers and challenges when it comes to providing that critical information. So again, a lot of our First Nation communities are struggling, again, with the Western legislation side of things, but also, again, just some of their best practices. So again, sharing that proper information, but also how do you do it in a good way that, again, doesn't contravene certain legislation or privacy frameworks. So again, unfortunately, in our experience, that data has always been, unfortunately, a deficit-based type of approach in terms of it being collected, and again, utilized in a colonial way that it's different is being viewed as it's wrong. But again, that's why it's so critical to develop those relationships with First Nation communities to see, again, potential repatriation or types of services or supports that they can provide to their members, even if they're off reserve or on reserve. So, Chimigratch.
Thank you, Michael. And Jody, I know you have a strong desire in building a strong culture of privacy in child welfare. It's not easy. So what are some of the challenges? I know Michael just talked about some of the pieces on the First Nations end. From your perspective from Durham CS, and I would say by extension the non-Indigenous CSs across the province, what are some of the challenges or considerations when applying Part 10 in practice?
Yeah, it's interesting. I think actually today's done a really good job of kind of identifying the unique challenge is the nature of the information that we hold. It's not just data, it's not just numbers, not to minimize the importance of a credit card number or a health card number, but these are people's stories. And we may be involved with a person for a day, a week, a month, or a lifetime. And it just really elevates the level of responsibility that we have. These records can follow people for their entire lives. And just the impact of that, I think we just can never, ever lose sight of that. We really, people can resurface over years, through wanting to obtain access to their information, whether it's because of court proceedings or, just wanting to know more of their story. I know our experience at our agency, we've seen adults who experienced abuse as a child and come back many, many years later. Perhaps their family is deceased and they want this information. And it's not a technical decision. It's those decisions have real impact and on people's dignity and their lives. I mean, we have examples that show up daily. We have examples of children that are in foster care, perhaps, and foster parents collect their information. They take them to appointments. They take pictures of them. They incorporate it into their lives. And then what happens with that information? They're expected to return it, and the chapter just is not there anymore. So those decisions are what's happening. We have parents that will ask us, actually, to collect their information. Perhaps through an investigation, they want to evidence that they're a great parent or perhaps the better parent. So they share a lot of information and they want you to collect that and take it. So it's our responsibility to have that conversation with them and explain what that looks like and what the impact of that could be. I mean, Part 10 really helps us slow down and ask these questions. Just because we collect it, should we? And we just, I think Part 10 is just really forcing us to maybe unlearn some habits. It's uncomfortable, but absolutely necessary.
Thank you. Alison, let me bring you in. And when I get into some of the consent pieces, there will be a few for Max to respond to on. But Alison, just from a legal perspective, have you seen or experienced any of these challenges in the enactment and implementation of Part 10 in your organization?
The biggest challenge, I would say, Solomon, lies in embedding judgment-based compliance in a high-risk operational environment like child welfare, while sustaining consistency under pressure and ensuring that privacy protection enhances rather than competes with child safety. And the reason I'm saying this is because we know that Part 10 is deliberately principles-based, right? It gives us a lot of flexibility. And it's that flexibility that gives us that compliance challenge that we see. So even within the agency, you may see different teams interpreting, sections of the Act differently and operationalizing it differently with the families that they work with. And so the issue for us, for lawyers, is really looking at the post-incident legal defensibility. How was it documented? Did they capture the rationale for their decision-making when they chose to use or disclose the information in a certain way? And yes, as Jody mentioned, consent within Part 10 remains one of the biggest challenges for our staff for compliance. Sometimes where statute gives us the opportunity to disclose or use information without consent and they ask for consent, it impacts us from a legal perspective. More significantly, I would say Part 10 arrived in a sector, that's our child welfare sector, with a deep, extensive collection of historical records. We have legacy systems with information collected in it. So there are compliance challenges when we're responding to records or even saying that I have given you all the records we have in our possession when we don't really know for sure because of our aging systems and our culture of retaining every single thing that we've dealt with child welfare, right? So this is so Part 10 sort of move the law along in a certain way, and whereas our internal infrastructure, it didn't evolve as quickly along with it. And one of the other things we see is inter-society inconsistency. So sometimes, families move. So a family will tell us, I got my record from Durham, and I got all this information. York, how come I'm not getting all this information? So those are some of the compliance issues, I would say, that we've seen that we've had to deal with.
So listen, before you drop the mic, I know we've talked about challenges, but I'm going to stay with you for a second before I move on to consent. We've talked about challenges, and Jody, you were talking about even sometimes the understanding of families, and they're asking us to collect more information than we truly need. So clearly, as a sector, what we need to understand is our role in sometimes education and even being able to explain to people what is embedded within Part 10. So would you say there are further areas of clarity that we need as a sector to be able to help support us as we do this work? And in doing that, how would that strengthen us in terms of our obligation and understanding of Part 10?
The mic on. So. Absolutely, Solomon. We do need further areas of clarification. And this morning, when James and Miranda spoke, they gave us a lot of insights and raised red flags or rang the bell to give us ideas of where certain areas of clarity would come from, right? We need. For instance, just a simple one. Posting notices about information in foster homes. Well, there's a worry there. We're institutionalizing our foster homes, and we're outing the privacy of the kids in that foster home. Imagine you're the plumber going into that home, and now, oh yeah, the foster kids in the home and that kind of thing. So our foster parents want to know how to be parents, how to be loving parents, while giving effect to these things, right? Or another, James spoke about, let's say, young people being able to share their information with the amendments to OREG 15518, where they can now disclose that they were involved in a proceeding. Okay, well, in child welfare, we struggle quite a bit to understand the regs ourselves. So who's going to help that young person understand what those regulations say? All they're going to think is, hey, I can share this, right? So how can we help our children's services workers share that information? We know for a fact that the Archives and Record Keeping Act does not apply to child welfare. And record management strategies, we're struggling to develop them ourselves internally. So yes, clarification on how to embed other pieces of legislation that don't apply, but we're supposed to live up to. How does that work? So there's so many areas of clarification that we need, and especially as we see the challenges that's coming with proposed amendments, for instance, around Section 291, the amendments to the proposed amendments to OREG 191.18. Who's going to explain how that's going to work to people in the field who have ongoing cases, and then they do an investigation in that case? Does it fall in a D, an E, what under subsection 35 sub 1? So, child welfare in and of itself is a very complex industry, and we are supposed to be moving into privacy by design 6 years in. And, Part 10 has weathered the storm of 6 years, and we're seeing changes, but we need help on the ground to make sense of it all. And especially since staffing for privacy is a nice to have. Privacy officers and that sort of thing, they're not factored into the funding formula. So if you're a smaller agency carrying a big deficit, that's a big issue for you. So I hope this has been helpful.
No, it is helpful. And it also links back to a question that I was posed in an earlier session today, where it talked about, do First Nations have a right of access to privacy records? And even in those discussions, we kind of got to a place where there was pieces around maybe a lack of clarity in Part 10. And so it's fair. As we identify some of these things, it actually tells us there's more work that we need to provide in terms of this clarity, because 6 years is still infancy, and we're all learning through the process as we go. All of you have talked about consent, so let's go there. Michael, I'll start with you. From the perspective of First Nations, what does consent look like? Because it's very nuanced in a number of ways. So what considerations should we be looking at when it comes to consent and operationalizing it within the First Nations context?
All right. One of the things to consider is, again, that free, prior, and informed consent for First Nations, right? It emphasized that consent must be given freely, without coercion, and decisions and actions being made need to be based on transparency and access to that information as well. As I mentioned earlier, is that, again, the issue with consent as well is that we have multiple legislations, both at a federal level and a provincial level, that speaks to it, but sometimes, again, they're nuanced in that they don't provide, they're guidelines, if you will, and every situation's a little different. As mentioned earlier, certain cases provide different outcomes. Again, different decisions could be rendered given the situation. Some First Nations may not want that information. Others may want that. So again, it's that balance there. And again, that importance going back to the respective First Nations and understanding what is allowed and can be shared as well. So, those are, with our agencies, they're also dealing with a lot of new requests too when it comes to information, especially for our First Nations that are taking up C92 and actually development of their law. Although they're not asking for personal information, they're asking for, again, some of those, generic numbers in terms of how many kids do you have in care of our membership. And so again, they can effectively plan in the development of their own laws as well. And again, adding another legislation to the mix as well when it comes to providing services to First Nation youth as well. So again, it's really critical that, again, as mentioned earlier, these are stories, these are individuals' lives. Unfortunately, again, we need to, a lot of these individuals have been affected by intergenerational trauma. So again, taking that lens as well as when you're, collecting that information or reading that information, it is, again, the need to understand where a lot of this trauma is coming from as well. So we're seeing, again, how that is going to be critical in, again, shaping their respective laws on how they want to help service their community members, regardless of residency. That's another challenge, is that we're seeing with many of our First Nations, is that, we're seeing many of our agencies right now, typically, they have a board of directors, and each of their respective First Nations that they service geographically are ultimately corporate members, if you will. They needed to provide band council resolutions to ultimately, under the old Part 10, create those organizations and become their mandated agency. But that information, again, what we're seeing is the mandate also comes with all Indigenous. So again, that First Nations that are not necessarily the members of those corporate members, if you will, those specific First Nations. So again, they're providing services to, in some cases, 100 different First Nations. Again, Native Child, just down the street here, they deal on average with 120 to 130 First Nations on a daily basis. So again, that could potentially, if they all enacted under C92, that's 130 different legislations they have to be mindful of as well. So that's going forward is one of the things too, is again, with all these types of consents and different laws out there, we need to be mindful of those and also learn new legislation and how we share that information with those new First Nation laws.
No, thank you, Michael. And I think as new laws come into play, you're looking at the impacts of C92 on privacy broadly. First Nations, question is, do band reps and chief and council have access? Do they need to be having access to some of this? Some of these are questions that are coming. And we don't need to answer all of it today, but that speaks to, it's only 6 years. So there's opportunity to build onto whatever we have on there for Part 10. Max, yes, you don't speak for all young people in this province, but here's what I'm going to ask you. What information would you need as a young person to have meaningful, to provide meaningful consent, as well as know that your information is being protected and dealt with well? Mm-hmm.
I think that I would take a little bit of a page from Michael's book here, and I think that I would need all of the information in order to give informed consent. I need to know everything about why, when, how, in what way, how a breach would be handled, use of child-friendly language in a way that people would understand. And every extra detail about confidentiality and how our information will be used to help us and the safeguards that are in place that will protect us. There has to be a significant purpose to sharing our personal information, and we must give full consent, full informed consent to have it shared. I base this in the UNCRC Article 12 that gives children the chance to participate in decisions pertaining to them. This means that children need a say in order to exercise their right of protection of privacy, and in this case, ownership of personal information. I would want to receive this information in an organized and timely manner with an adult who is sharing this information, so I can ask questions and have the support that I need if that arises. They also need to be able to provide me with the the necessary protections that come with sharing information. I think that the number one thing is to just talk with me and try and scope out how I feel about the situation and what sharing information looks like, and in this specific case, ensure that that you as the worker don't overstep boundaries that I place and give information that I don't want shared.
You said something interesting here. You want all the information you need to give consent. You want it in a child-friendly language. Alison, can I put you on the spot here? How does a lawyer take Part 10 and translate it into a child-friendly language?
That's a really interesting question, Solomon. Interestingly enough, it's not the lawyers. We have to break it down for our staff to be able to have those conversations with the children and youth that we work with. So we do a lot of training with them. We do little videos, we do role playing, and we give them some scripts and supports to help them do that. But we let them take the lead from the young people. We always let our workers know that it's so important to get curious, ask questions, take the cues from the young people, and make sure whatever they say is age appropriate. You can explain the concept of consent to a 7-year-old just as you can explain it to a 17-year-old. You just have to target your conversation depending on the age of the child. So yes, it requires a lot of ongoing conversation and helping our workers build that confidence.
Thank you. It's good to pull a lawyer on the spot, right? But Max, that speaks to more of the work we all need to do to get to the place where, yes, like you said, you don't speak for all young people, but I want to truly believe that every young person wants all of this information to give that full and informed consent. So thank you for sharing that. Speaking of consent and everything else we've heard, we still have to deliver service. And there's almost always the tension between what we call protecting privacy and then having information to deliver service. So, Jody, I'll come to you to start this one. How do you deal with that tension?
Well, I would suggest that our service teams actually in the field that we're in, the sector that we're in, the humanity of the work that we do, they navigate, I don't know about me, but they navigate tensions constantly. We have service teams that if it's not privacy, it's some other type of tension, and they navigate those on a regular basis. It's part of the work that we do in the field that we're in. We understand that child welfare information is extraordinarily sensitive. We're all agreed on that. But also we can't treat Part 10 as a extremely rigid rule book. We count on our lawyers. We lean on them a lot to break down the conversations. We can always rely on a lawyer to say it depends. So that's helpful, actually, because it makes us look at the facts and look at the information and have an informed decision. And I have to give a shout out. I really appreciate the information earlier from the IPC when we got the guiding document on intimate partner violence. That was really helpful. I really appreciated it. It recognized that post-privacy decisions are often safety-driven. And it was just such a great example of the tension and struggle that we're experiencing all the time in different ways. We work with community partners, we work with police, we work with schools, we work with hospitals, and there may be times we need to share limited information to assess immediate safety. Just examples, we could get a call from a school principal saying, with what appears to be a privacy complaint, that a worker overshared information, but then when you dive down and you talk to them further, you understand that that school is an integral part of the safety network and the safety planning for the child or the family. So there's always kind of more to the story. I mean, we continue to work and understand where the line is. And then, of course, as we're just talking about, it's how to explain those decisions and why they're being made to families and as well as to our community partners. Of course, like Allison's saying, on a micro level, we're coaching our staff to be transparent with clients, and the hope is over time that this is the information, we're letting them know this is the information that we're sharing and why that's necessary. Ultimately, I suppose the hope and intent is for honesty and transparency to build trust, even when those decisions are really hard.
Thank you, Jody. And you can't talk about tension and not bring the lawyers into this conversation. Some say the tension is perceived, others believe it's real. So from your perspective as a lawyer, how do you approach that balance in real world situations? And is there any specific example, real world, that you can share with us?
Sure. So in real world child welfare practice, privacy and information sharing from our perspective are not opposing values. They are both child-centered safeguards. So for lawyers, it is working with our staff to not choose one over the other, but to help them exercise judgment so that information is shared purposefully, proportionately, and defensibly. So from my experience, that balance is achieved one decision at a time, because no two cases that you're working with in child welfare would ever look the same, right? So as lawyers, what we do is we do a lot of reframing. So we pose the questions differently. So our workers may come to us and say, can we share, or am I allowed to say this? And we would reframe it as, what outcomes are you trying to achieve for the child or youth? So we get them to shift the thinking. What information is actually necessary to achieve that outcome? And who genuinely needs to know it? Why? And why right now? So we do a lot of that. We try to get workers to pause, because as you know, in our sector, we usually have to make snap decisions at 5 o'clock on a Friday. Should we bring this child into care or not? So legally, what your lawyers do is work very hard with staff to ensure that urgency and how we react to urgency doesn't replace analysis. So we do a lot of that pause, breathe, get curious sort of conversation. So we talk about if the disclosure is urgent, we talk about whether delay would cause risk to the child. So we have those conversations. We also try to separate relational practice from legal authority. So, in child welfare, we do things a certain way. We develop a culture. We do this because we've always done it a certain way. So as lawyers, we always have to reframe the conversation in the context of legal authority, bring it back to legislation. So for instance, we have conversations around consent. We always have to bring it back to statutory authority and not just relying on consent, because it keeps a good relationship with a family. We look at respectful engagement and transparency. So we always talk about when we're talking to families, consent is a conversation. Make sure it's ongoing. Make sure you capture it in your contact logs. You capture the rationale. You always revisit it with families, and we try to coach around papering over things. So by taking this approach with staff, we try to maintain the integrity of the privacy rights of our children and families, as well as maintaining professional relationships with our clients, as well as the people that we're serving. And of course, as lawyers, we always insist on documentation, right? If it's not in a contact log, it did not happen, because for us, that's where we go to defend our organization when the IPC lands or we have to go to court, right? If it's not in a contact log, it didn't happen. And make sure you capture the rationale.
Thank you, Alison. If it's not documented, it didn't happen. And it's not only for lawyers. You go to the health field, everywhere, you need to document it. So thank you for that. Max, let me bring you back into this conversation. We're talking about tension right up there, or perceived tension, or however we want to call it. What will signal to you as a young person that an organization, any child welfare organization that you are dealing with, takes your personal information seriously and they truly care about your information?
I think that a young person can tell when their information is taken seriously when they are met with understanding that, their words and personal information hold meaning to the receiver. That means attentive listening and eye contact and asking follow-up questions and seeming generally happy to be there listening to the young people. A scenario for you. Imagine you're at a hospital and you're trying to tell them what's wrong, but the triage nurse had accidentally written down the wrong reason as to why you're there. This leads to you not getting the proper care, and your information is thus misused. And you won't feel seen or listened to. This is a very important part of your medical care, right? Well, sharing our information that could be wrong or outdated may also create those kinds of problems for us in the same way. We won't get adequate or proper care if we aren't taken seriously or if receiving false or outdated information, or if we give you false or outdated information. Another way to tell that a receiver cares and is listening to us is that if they use the UNCRC Article 3, that is to adults must act in the best interests of the child. This means that a receiver of information uses it only to benefit the young person and not for personal gain or against the young person's wishes. And that if there is an issue with the correctness of the information, a youth has a chance to change it so it suits their needs better. In my personal experience, I have learned that I am way more willing to give information. Sorry. She is not my friend today. I'm so sorry. In my personal experience, I have learned that I am way more willing to give information if the person is attentively listening to me, asking questions, and taking general care to ensure my comfort, especially when talking about sensitive topics, and that I know what this information will be used for and how. Also, just talking about it beforehand and remaining transparent, as it's been illustrated, about what has been shared, and offering to remove it if possible, when the child no longer wants the services, is helpful to building that trust and rapport before continuing care.
Thank you, Max. And what I heard there in summary is young people are not against sharing their information, but they want to be sure that the collection, use, disclosure, and retention of that information is done with the proper controls and guardrails in place. Thank you for sharing that. Jody, I have a question for you. Moving on to compliance. What are some of the frequent mistakes or misconceptions you see when it comes to Part 10 compliance?
Right. Well, I'm not sure about mistakes specifically, but there's I guess maybe it is a misconception about like privacy being a barrier to good work and to good service. I think we kind of, maybe that's from past practices or old ways of thinking, I don't know, but that's definitely the shift we're trying to make. The worry is that Part 10 exists to share, to stop information sharing, and that, privacy leads are the office of no, and that, we create barriers to what we want to do, or innovation, or projects, or processes we want to shift and change. And we really want to change that thinking. That thinking tends to lead to over-collection and recording everything just in case, without clear purpose. And that kind of thinking also leads to privacy paralysis. It's not uncommon for me to get calls from workers asking if they could go into a file or read a file that they actually need to do their job. And, so we're tackling those kind of, like somebody said, I think kind of one question, one circumstance at a time. But I think it kind of ties along with treating privacy as like a back-end compliance checkbox, and I think that's the work we're all kind of collectively trying to do, is to shift that. I know we had ministry guidance documents, privacy impact assessment samples, and we've tried to implement those. And those, they go a long way. But again, it's not just one person completing a privacy impact assessment. It's a collaborative piece of work. You need to, input from a number of people throughout the agency, and then I think there's value in it. You break down the privacy principles, you work through all those elements, and then you can kind of really get some learning and some traction, and also have confidence that the project or the process or whatever has gone through that assessment. So I think there's great value into using those tools and to really embedding, but I have to give a shout out to the importance of having privacy champions at leadership tables. That's where those decisions are made, and that's where change management processes start, and it's just so critically important that those people are there raising the flags and saying, reach out to your privacy lead, go through these processes, and hopefully for better outcomes. Again, it's great to see those IPC guidance documents coming out, so we can also segue those into those processes as well. And yeah, I think that's...
No, thank you, Jody. And audience has been very good. So I'm going to reserve some time for you to ask questions. Before getting there, my last question to both maybe Michael and Alison. As the sector continues to evolve, what are some of the emerging issues that we would like to keep our focus on how we want to, and to help us shape how we interpret and apply Part 10 in the future? Any one of you?
So again, one of the things for, again, how Part 10, for many, and we're running into this situation right now, is with some of our community members and their children, is that often many of our children, they have the option to be registered with multiple, again, mom's First Nation might be X and father's might be Y First Nation. And so one of the things, though, is what legislation applies in some of those cases where one of those First Nations have created their laws. So again, that's one of the things we're seeing as these laws starting to develop, is raising those questions. And again, unfortunately, what we're seeing is we need court to intervene to interpret, to provide, again, some of those some of those guidelines and frameworks on how to interpret these different legislations. Because again, what we're being told on the C92 side is that those laws ultimately have precedence over other legislation, be it federal or provincial. But at the same time, that child belongs to two First Nations. At the end of the day, so again, it's those types of things where, again, some First Nations are adamant that, they're allowed services under their law, but also at the same time, some of, be it mom or dad, want services through their First Nation. So again, one of those things, those are some of the issues we're seeing, is unfortunately not all legislation, nor should it be, identifies every issue or an answer to every situation. And again, it gives you those those kind of those benchmarks where where it should apply, where it shouldn't, but also gives that discretion to the First Nations and their sovereignty as well on making those types of decisions for their children in placing or the types of services being offered to them. So that's one of the things we're seeing is, again, more and more First Nations as they go down that road, and we're seeing that. I believe the last count was about 20% of the First Nations in Ontario. There's 133 First Nations. They've actually signed the intent to develop their own laws. So we currently have 3 and a 4th First Nations that actually have developed their own laws, and likely more to come in the coming years too. So,
Alison, anything else to add? Mm-hmm.
So, we've lived Part 10 for 6 years, and it stood up well, I would say. So as the child welfare sector continues to evolve, I would say future interpretation and application of Part 10 would be shaped less by the wording of statute and more by the environment in which it operates and in which we live. And I think Commissioner Kasim talked about that this morning, about the impact of environment on shaping Part 10, right? And we've talked about during the day several emerging issues that's already influencing privacy obligations and understanding. We talked about new contexts in which we're working. We talked about technology, AI, truth and reconciliation, and how great it would have been if CASs had some guidance on how to share information with First Nations trying to assert their jurisdiction under the Federal Act. We see the rising need for equity-based accountability, right? That is topmost in our society right now. Youth autonomy, we've heard Max's voice. We've seen how the government has responded to that request with the amendments to OREG 155.18 and 191.18. So I think that will be something we will have to keep our eye on. And of course, integrated services. How is that going to shape how we do our work in the future? And the reason why I say that is because we can't protect children alone. It's not child welfare, CASs, we can't do it alone. It's a community response. It's a community responsibility. And in 2018, the sector, we started talking about child welfare redesign and what that would look like and how we would all work together to keep kids safe. The conversation sort of died down, but the work that we have to do on the ground as children's aid societies remain. So we still need to do the work. So I would say we would see what's going to be shaping how Part 10 evolves is sharing information across sectors. We really want some guidance there because we don't want to have to keep developing information sharing protocols with everybody we work with and all of that kind of thing, right? We want to be able to share information lawfully and to be able to have timely collaboration. We want to work with our 16 and 17-year-olds, and there's so much hesitancy around sharing information and what that looks like when you're working with the youth on a voluntary basis. I think that's going to be critical, and how information is collected and shared can reinforce bias and systemic inequalities. We know that from what we've lived. So I think the conversation around equity will continue to shape Part 10. Also, access requests under Part 10 are evolving from administrative processes into accountability tools. And we see that when service recipients get their records, then we get the complaints, we get the ICRPs, we get the CFSRBs, we get the human rights complaints. So that's another area. I would say future maturation of our institutions and how we're required to work will also impact Part 10. Also, how other privacy legislation like PHIPAA and all of that, how that's developing, I think it's going to impact the work of Part 10 and how we use it. And we saw that with IPC Decision 19 and the Hospital for Sick Kids, how the judges were flipping between the two pieces of legislation. So I think it's going to be really interesting to see the evolution as our social milieu evolves and the environment changes.
Thank you, Alison. Evolution means more to come. But this is all the time we have for now. We're going to make time for a couple of questions from the audience. So, Commissioner, if you want to join me here. When there are tough questions, you direct them to the Commissioner, right?
We'll start with some questions for the panel, and then we'll transition some new folks up. So, but first, big round of applause for the panel. It was excellent. And then, I know we had a few in the queue for the panel while they're up, and we'll be bringing up the commissioner shortly.
Okay, so confirming no questions in the room. All right. There's a lot of talk about the cultural shift. What's the process if the shift isn't upheld?
Anyone can jump in? Culture shift?
I'll take a stab at that. What's the process if the shift isn't upheld? I would say at this point, because we're talking about the infancy of privacy development as a whole, there's a lot of collaboration and patience and support being given to each other. I think that's kind of where we're at as a sector. I don't know if anybody feels differently, but I think it's more about kind of reinforcing. I know when we work with families, we talk about what's working well, what's not working so well, and then kind of next action steps. So I don't know, my approach to that would be, really assessing what's working well with the culture shift and maybe what's not working so well. We can put in some supports around that, and we have always a list of action items, so, yeah.
And just in addition to that, I'll say anything worth doing doesn't come easy. So it's not going to take easy baby steps to get there. It is going to take, culture doesn't shift over a day or two. It is going to be progressive. But I think what is important is how we look at privacy and data. We don't want to look at it as a side issue or something else is a job of the IPC. Some of the earlier commentaries someone said is privacy is a core child protection issue. So if we are doing child welfare and you begin to look at the child well-being to include the privacy of that child, it changes even the mental way of how we think about it, and that should transform how we practice it in our day-to-day going. So I'll say it's got to be an ongoing reinforcing leadership being on it and making sure this is our work. Let's get it together and let's do it together. Consistency will get us there.
All right. We also have a question. What are the anticipated biggest impacts or changes of Bill 188 on direct service staff, so staff who complete protection investigations?
There's been so much conversation about the impact. I can see a chilling effect on our staff, for sure. I know we've had 6 years of a lot of work with our staff to get them comfortable with working within a privacy framework and understanding the nuances, working in a contextual environment, and using their judgment. And it's because, risk aversion is a real thing in child welfare, right? Workers want yes or no answers, black and white, because the consequences can be grave. There can be inquests and ombudsman's reports. So nobody wants to be a part of that, right? So when you look at the changes that we've seen this morning that James talked about, they're as clear as mud. So it's going to be very, very difficult for our staff on the ground to make sense of it. So the impact is going to be a further chilling on our staff and further hesitancy, and I would say a greater risk aversion. They're going to be looking to us. Lawyers will be getting a request for legal consultation every 5 minutes. Can I do this? Can I do this? What should I do here? So we're going to be, I think that's going to be the biggest impact on how our staff do their work.
All right, thanks. Are there outreach programs or plans to develop educational structures or materials for young people on their privacy and consent rights?
Organizations, agencies, individually, we do develop our resources for the people we work with, for the children and youth that we work with. But it would be really great if somebody can do that for us, and so that we have a consistent approach. I don't know, Jody, if you wanted to jump in, and Max.
Yeah, I'm just going to jump in and say that if this is needed or that youth ask for this, or if we feel like it's something that we want to do for youth, that's what our youth council is for. We will make these structures or materials or brochures or educational videos I've even made for things that if youth need information on. And so if that's something that's important, we will make that happen.
Sorry, can I just add, I know that the IPC has the privacy pursuit. They've actually got some resources out, and I know in our agency we've got an educational liaison. I've distributed those materials out to them, so that's kind of been our segue until we can get those next steps in place as well.
Informed consent related to the Ready, Set, Go program. So we've asked it to be updated to our website. I can check when I get back tomorrow to see that it's been done, but it's very much specific to having very informed, fulsome conversations with youth about the collection and sharing of Ready, Set, Go information with the ministry. So, thank you.
Thanks, Lauren. Just to add to that as well, one of the things out there too is, again, working with Aboriginal Legal Services, they had a program called You Wait None. So again, that's more of a mediation, if you will, with children's aid societies and families. So again, having that circle process, Anishinaabe Legal Services also talking together circles. They have provided that too, where they help support families and youth, again, informing them of their rights within the child welfare sector as well. So yeah, so just not necessarily internally in terms of CASs, but also there's outside supports as well too.
Okay. And any comments on how to encourage frontline staff to move from thinking about confidentiality and privacy as a side issue?
I think it's just a shift. I think it's all just a shift we need to keep making, right? I love the comment about it being a core issue earlier. And it is a shift, right? You need to get your mind around it a little bit. And I think it's just kind of keeping those things in place, relying on your colleagues. I argue that everything we do is collaborative by nature. So, taking the learning from your colleagues, from your supervisor, from your team, from those around you. I know as a privacy lead, the shift for me is done with my peers. We have the OACAS group with the privacy leads. I lean on them a lot. You do it together would be my kind of suggestion.
And to kind of build off of that, I think workers can keep that in the forefront of their mind by just having that conversation regularly with their youth and talk about what that means to youth and what youth expect from that, as well as some of the rights-based approach. As I was talking about UNCRC Article 16, it's something that not a lot of youth know about. So I think that the way to encourage frontline staff to keep thinking about confidentiality is to have those conversations with youth.
Yeah, and when we socialize our staff to the CYFSA, we always start with it's embedded in rights. It's a heavily rights-based piece of legislation, and the information belongs to the children and families and the youth we serve. They're the rights holders. So that's our starting point with them. So CAS is what we try to do is move from just reactive compliance. We're moving into governance, embedded governance. We're moving into privacy by design so that when we onboard our staff, we have training modules for them from the get-go about privacy, embedding it into service. We have annual trainings for them. It's embedded in performance management systems for our staff. So if our staff see that this is core to the organization, it's fundamental, it's a huge governance issue, that leadership is behind it, it becomes part of the DNA of the organization and we start thinking it. So I think that's critical for our sector.
Thank you.
Yeah, thank you. And thank you for the questions. We're going to have the commissioner join. She wanted to share a few reflections on the day. Stéphane Luciu, my counterpart, will also join. Ask the panel members to stay. We'll kind of have a final, I'll call it a super Q&A at the end, and with everybody, and we'll get underway. Thanks.
Thank you so much to this incredible panel, and thank you to the moderator who did so well navigating all those questions and keeping us on time. I have taken notes, but unfortunately it's pretty messy because my mind and my brain is going at 1,000 miles per hour. But I must say that at this session, like other sessions, I do go back and listen to the webcast, because there's so much that I'm trying to take in the first time around, but it's only afterwards when my mind is at rest and I can listen to the webcast again that I take in so much more value in the discussion we've had today. So I certainly will plan to do that. But in the meantime, I'm just going to highlight a few of my notes here that I've put an asterisk next to, because that's the kinds of things that that really marked me. Jody, first of all, thank you for, again, reminding us this isn't just about data, but about people's lives, people's stories, and these are not just technical decisions. They have impact on people's lives and on their dignity. I think you're the first client I've ever heard say that they appreciate when their lawyer says it depends. I've never heard a client say that. But it's a nice opportunity, as you said, to say, okay, then I do have to go back and look at the facts and think about the situation and the context. And so it's a nice invitation and reminder to do that. From the legal perspective, Allison, I really appreciated hearing your practical on-the-ground compliance challenges, the reality that there is inconsistency across societies, the challenges around records management, and also many of the legal gaps that remain, the interpretation challenges, but also the critical practical challenges. I've never thought of transparency notice or public notice in a foster home institutionalizing that child's home. And that's a wonderful reminder of the inadvertent impacts sometimes that even well-intentioned legal requirements can have in the lives and in the homes of children. I really liked you reframing the question when you're asked by a client, can we do this without consent, reframing it by first and foremost asking, what is it that you're trying to achieve? And turning the question around. Michael, thank you for reminding us. I've got a double asterisk near this important statement you made, which is really strikes at the heart when you referred to the child welfare system as today's residential schools. That's a double asterisk for me. You reminding us of the evolving context of First Nations communities, the importance of data sovereignty and self-governance, but even the practical challenge you raised when the mom and dad are part of different First Nations. And so, of course, we want to give primacy to First Nations laws, but what do you do when there are two at issue or at stake in a child's life? And thank you for reminding us we have a big and long road ahead in terms of consultation and relationship and trust building. And Max, if you're ever wondering the most powerful, this is triple asterisk, if you're ever wondering what to do, think of Max's question. How would you feel if ... That to me expresses the kind of empathy we need to develop for our children and our youth, and to try to understand things from their perspective. They want to feel seen, they want to feel heard, and as Max said, just talk to me. So thank you for reminding us of all of that. Last observation, I just want to say, I hope that there are people from the ministry here. I don't know if there are, maybe there are some listening, but so many things came up in today's conversation that really merits some reflection on how the law can be further clarified in order to address certain gaps. As you said, or somebody said, we don't need for every situation to be accounted for, but there are clearly some gaps from a practical perspective, listening to all of you on the ground, that are worthy to address and take into consideration. So those are my reflections. Thank you so much for teaching us and for the opportunity to learn from you and to hear you. And now I think we'll open it up to the floor.
Yes, thanks, Commissioner, for summarizing some of those key calls to action and items for us to take away. That was excellent. And yeah, we'll now open it up. It's, as I called it, the super Q&A to the panel. And by all means, the panel, feel free to jump in as we were doing. But we've brought up the whole team. So I'll hand it over to our question moderators if we have anything in queue. And if there's any questions in the room, again, we have the roving mic.
All right.
Do we have a question?
All right.
So I'm just curious as to how race-based data collection is viewed in regards to it being part of the personal information of a youth in and from care.
I need my legal lawyers here. I don't know if, is the child sector one of the sectors that's turned on in the regulations? So, okay, now that I've got that clarified, what's the question again?
So I'm just curious as to how that's going to be disclosed and shared.
Yeah, I think we don't have much yet experience in implementing the Anti-Racism Act, and in particular, the disclosure requirements and the collection requirements. So I don't really know how we would contribute or intervene in those kinds of cases. I know that this is something that our staff cares a lot about, and when we were consulting on our strategic plan, many have said that, you know, if given the opportunity, we need to do more in enforcing and implementing the Anti-Racism Act. So certainly we will look for opportunities wherever we can to advance the important principles behind that legislation.
Perfect, thank you so much. And is there time for just one more question? Yeah, perfect. So I'm just curious about the process for obtaining disclosure. So I know we talked a lot about ensuring that we're protecting the information being collected, but when that is disclosed, I'm just curious as to what the process is in regards to youth obtaining it and ensuring we're also protecting their psychological safety. I do believe that it's really important for youth to be able to access this information. However, are they just accessing it and then having to read it on their own? And yeah, what's that like?
I can just tell you our practice at York CAS, we do have child protection workers who work with our Access to Information and Disclosure team. So they do stay in close communication with the youth, and they are able to sit with the youth and review the records and try to explain as much as of what's contained in the record to the youth in a supported manner. That's our practice. I don't know if there are any other practice, Michael?
One of the issues, going back to your first question, was one of the things that we're seeing with CPIN is that there's actually 5 areas in which you can identify as Indigenous. So again, it really complicates things on the, on the worker side, what section to fill out and when and all that stuff too. So that it raises that complexity, and again, it could be often, misinterpreted or checked off in different ways. And so again, there's some complexities there just within CPIN. I know only about 2 of our agencies, well, I think a third Indigenous agency is on there. But again, it creates that complexity. And again, on the Indigenous side is, again, there's special provisions for specifically First Nations that, and again, going back to the 65 Welfare Agreement, there's actually a charge back to the federal government. But those are some of the reasons why, as well, that obviously why we collect that information is ultimately to enact certain provisions and, again, proper notification to the respective rights holders as well. So.
Sorry, I was just going to add on the second question, add on to Allison's comment, about youth or anyone actually getting access to their file information. I know our A&D team, when they review the information, not just with youth, but in any circumstance, if they feel the information is not going to be received well or for whatever reason, they'll even suggest the person might want a support person with them. And they have that dialogue kind of through the process, so the person can feel supported if needed. And
Perfect. Thank you so much. I appreciate it.
Great questions. Yeah, we'll bring a mic over to you. Just give us a sec.
Thank you, thank you. I run a small education organization, and we are in the planning stage of a pilot program for elementary students. From privacy perspective, could you advise how can small organizations determine whether they fall under Part 10 or PIPEDA or the education framework when working with minors? Thank you.
So you said you're a small educational organization. I don't know the details, but please speak to our lawyer afterwards, James. But in terms of just generally, let me just back up a moment. Your question is good because educational institutions, primarily schools and school boards, will fall under the Municipal Freedom of Information and Protection of Privacy Act. That also has extensive access and privacy obligations and important requirements to protect students' data. We work very actively in that space to support schools and school boards to respect students' data. We've developed a digital privacy charter, getting them to sign on to 12 commitments to both protect students' personal information, but also empower them to make meaningful choices and decisions about their use of personal information, things like the kinds of educational technologies used in classrooms. The other thing I would just add is, so we're very active in that space. It's an area that we take very seriously, and we would be pleased to share our resources with you. One of the things I wanted to say also and mention to Max is that we have a youth advisory council at the IPC, a group of 10 youth from 15 to 22 years old, just a powerhouse of young, bright minds who have tons of great ideas. And one of the lessons we learned from them is the best way you educate youth and students about privacy is by creating and nurturing an environment where they can learn from one another and really developing those peer-to-peer systems and conversations. And so we're working very hard to do that. And I would like to publicly extend a warm invitation to Max to maybe meet with our Youth Advisory Council and one day come as a guest participants in one of our meetings and get to know them, and maybe the sparks will fly and you'll think of great educational resources for the child and youth and family services sector.
I'd love to give that a try. Thank you.
Any other questions from the floor? All right, maybe we'll go to a couple online, Sandra.
Okay, this is directed at the IPC, but I think others would likely have comments as well. How does the IPC see Part 10 guidance evolving on parents' access to children's records while ensuring youth aren't coerced into consent or penalized for denying it?
First of all, any ideas for guidance you should be sending to us. We would be happy to onboard suggestions, areas that you're struggling with, and develop some thoughtful guidance around those issues that seem to be common amongst several community members and workers and service providers. The other thing I just want to say is we were very happy to issue our first interpretation bulletin, and we will continue to do so. So as guidance becomes available through our adjudication orders and decisions, we will continue to codify them into sort of practical principles that you could apply in the sector. And I think that form of guidance has been very well received. We've gotten lots of great feedback. So we've issued one, but we intend to, of course, continue in developing that guidance. And cases of note as well. And of course, the ongoing education guidance like Yes You Can brochure and disclosure guidelines in situations of potential harm.
All right. This one sounds fairly technical, but and I believe that the person who's asking is a social worker. But the question is, how can we reconcile clinical notes collection per college directives with the privacy principle of collecting only relevant information for service?
Yeah, I know, Jody and I are playing tag here. That's a common situation that arises in child welfare, because how do you know you're not going to need this somewhere down the line, right? Because we are asking our staff to collect only what is relevant, what is necessary, what they need in the moment. It's how the contact logs, I think, are crafted. If there's rationale for collecting the information, why they're collecting the information, that's defensible. That works for us. Jody, I don't know if there's anything you wanted to add.
Well, I would just add the reverse is true as well. If information is being provided that we don't need for the purpose of our role, is to provide the rationale why it's not needed. Yeah.
So I know we're running out of time, and we're going to proceed very soon to our closing remarks and prayer. But before we do that, and I don't want to put you on the spot, but Solomon, you have so much rich experience. You've been the moderator asking everybody's questions. I just wanted to know if you had any reflections on the day or things you wanted to add before we wrap up this panel.
Thank you, Commissioner. So earlier in the day, I have one of my staff members here. Is our privacy officer, not commissioner. John Van Til, he's our privacy officer for OACAS. And so earlier in the day, I sent him a message. I said, John, I see people in the room. I think there's a bigger audience that needs to hear this. So I was talking to him about possibly connecting with the IPC to consider a webinar for the sector where we can have executive directors, directors of service, privacy leads, legal counsels, and a few more frontline services. So I think there's something here that shouldn't just end with this group here.
Excellent. And just so that you know, and if your colleagues are interested, this session will be webcast. Recorded and webcast and available on our website for anybody who wasn't able to attend today. And John, it sounds like you just got promoted. Thank you.
Perfect. Yeah, thank you, everyone. Thanks again to our panelists. Thanks, Commissioner. Thanks, Stefan. Big round of applause. You guys can make your way back to your seats as we transition. As the Commissioner mentioned, we will have the full video on our website as well as the presentation materials, so keep an eye out for that. We've made reference, and please take us up on that offer of reaching out to us. You've made contacts here. Don't be shy. Let us know what we can do to best support what we've heard throughout the day this community that's working to solve these challenging issues. You'll be receiving from us a short survey evaluation form. Very important, particularly as we're heading into our third session. Your feedback is critically valuable to us to keep making these sessions better and better. So thanks for taking a couple minutes to do that once it lands in your inbox. I was reminded you can leave your tags. We will recycle, reuse them. So instead of throwing them out, if you wish, you want it as a souvenir, by all means. But if you want to leave them behind, we will reuse them. We're at the point of the day where we're going to wrap up, as I mentioned earlier, with some closing reflections and a closing prayer from Danette. We are honored that she's spending this time with us and sharing this opportunity with us. I will say, if you could please remain with us through this particular session and the prayer, out of respect for those who are here and those who came before us. So I'll bring Danette up to the stage and we'll get underway. Yes.
All right. Miigwech, Michael. All right. What a wonderful day. Minoshkana kwek, kinagwea. So again, my greeting to say good afternoon, everyone. It's been a really incredible day of sharing the knowledge that everybody brings. Just complements everything that we work for. You know, we talk about progress, we talk about change. It takes a lot of people to make change. And sometimes it's pretty slow. And as much as we would like things to happen a little faster, we just have to be patient, but diligent and not give up. So one of my closing comments I wanted to share was a teaching about that my auntie had shared with me quite a while ago. She said, the Creator gave you a mind and a heart. So she said, you have those two machines, she called them, have to work together. So when you have intellect, she said, and use your mind, you just can't walk out the door every day and work from here. And from an intellectual point of view, this has to match your heart. So when we talk about the expertise that everybody brings, you know, to their work, to this workshop, we always have to connect to the heart. And that's some of the stuff that I shared this morning about the human spirit, that we are in the business of dealing with people's lives each and every day. Maybe not directly, but indirectly. Whatever we do and not do is going to have an impact on somebody. So that's something that we always have to remember when we participate in designing something to improve, to call it success. You know, we have to be able to measure what that success might look like. So it's a transition from, you know, what used to be the way we used to do things, such as privacy, into making that transition into what it's going to look like today. And to be so inclusive, I can't stress that enough. We have a youth sitting at our table too, joining us, and I always said, the youth of today are tomorrow's parents. What are we doing to invest in those parents? You know, and today we heard that giving them a voice so that they can also advocate for themselves, that we protect the integrity of who they are and their story. It's not to be exploited. You know, it's their story. They got from point A to C, B, C, D, and where they are today with hardship. It hasn't been a pleasant journey. So we have to make sure in the validating process that we protect that and not exploit it. The elders have said, we've had a meeting with the ministry a little while back, about a year ago, and we talked about the data. And the elders said, what are they doing with that data? Why do they want it? Pretty good question. Pretty good question. So who could answer that, you know? Who can answer that question? What are you doing with it? And they never asked us for permission to use it, because those stories belong to our families, our children, our communities. They belong to us. And before those things are exploited and used in different ways, we need to know what for. What's the purpose of all of that? So it's really important that, you know, every aspect of, you know, IPC, I'm so glad I came. It's my first opportunity to really participate. I've sat with Lorraine on a couple of meetings, but to really get a clear vision of its intent. So I just wanted to, I also wrote something a little while back, and I wrote, our children are teachers, and they teach us what they need and what they need to flourish, to be nurtured, to succeed, to belong. And as I mentioned earlier this morning, belonging to a culture, belonging to a language, to the land, and everything that comes with it. They need that, eh? And they have been exceptional teachers, because the minute they are removed from their families, trauma begins. Yes, they might have been experiencing some level of trauma, why there's intervention, but they continue to experience trauma over and over again. I told the ministry, I said, let's look at protection. Convince me how you're protecting my children by removing them, because we have that two-year window. Like, not so much now, we have customary care, but, you know, every time you move my child or my children from different foster homes, they get re-traumatized because they're trying to fit in. They're lost. They're trying to fit into a world that's so foreign. They have no, that's not the way they lived before. So, but their care is going to generate numbers also for the next upteen number of years. Those traumas will manifest into complex issues, physically, mentally, and spiritually. They will learn to disconnect. And so their needs become greater and greater and greater. So we want to be able to do things differently. So to me, protection should be just intervention. It's an opportunity to visit with that family and figure out what can we do differently. And sometimes maybe there's nothing we can do. It's got to run its course, and that's okay. But it doesn't mean that the child has to relinquish totally who or she is in terms of identity. I also have a little note. I really like the commissioner's comments. She's got asterisks but on all the little comments she was going to make, and I didn't have time to do that, to prioritize kind of the ones I wanted. And then with regards to data, why can't First Nations access their data when the ministry is still doing it? Why? It's been First Nations leadership, jurisdiction to look after their children. They've built these agencies to be able to provide that direct service. And yet, you can't access your own data to provide that service, or the history, it just doesn't make sense. Why? And so when I was sitting there listening to that, that's when I remembered the teaching that intellectually, yes, maybe it is a form of self-government. Yes, maybe it's a stepping stone in the right direction, but there's some complexities attached to it and some barriers that prevent you from doing the work 100%. Why is that? If we endorse and support and it's a good idea, then let's roll out the red carpet all the way. I make it sound easy, I know it's not, but I'd like to make it sound like that. Meaningful consultations. I like to believe, and I do believe, I should say, is that the people that you need to visit with sometimes are the experts at the ground level, at the First Nation level. They work with the complexities of child welfare legislation on a daily basis. So I always say, please make time to visit and consult with our communities through the agencies or, with the assistant of an ASIO to help coordinate. But you need to listen to what those challenges are in terms of, confidentiality, the data, and everything else. You can't forget that I always remind people when they're doing a presentation for the elders don't have the same jargon as you do because you work with it every day. You talk, your conversations, your emails, correspondence, everything speaks that language, right? But for them, they're not technicians. They're not technicians that work with that kind of data. So you need to be mindful about how your material is reaching the right audience and how you're delivering it. Always to be respectful about that. And that's really important. I think one of the, when I said children are our teachers, I was teaching for a little while at our community school. I was teaching language. And Mother's Day was coming up. So one of the highlights of the school was to have a Mother's Day tea. The kids, they decorate the tables, they invite mom to come for the afternoon for tea and cookies and all that. I regretted that experience for so long because in my classroom, I had completely forgot about this one little guy. He was about 6. He had lost his mom through illness. And he was sitting there looking at his paper. He couldn't make up, they were making Mother's Day cards too. And I said, I went to him and I said, are you having problems getting started? And he put his head down. And he said, yeah, because I don't have a mommy anymore. She died And I just thought, oh my God. I felt so bad. Like I forgot all about him. I knew that had happened. And so anyways, I said, he also had some other siblings in the other grades, and I knew they were going back home to do a celebration and a feast. So I said, how about you still make a card for your mom? And when you go to the graveyard, you could bring it there and put it there. Yeah, he says, eh? And I said, come here. I said, come to the desk. And I said, would you like to have a smudge? He said, yeah. So he had a little smudge, a little ceremony. And then when he did the smudge, he passed it up. And that one's for my mom, he said, eh? When I say children are teachers, they're the most powerful teachers of all. But yet, we're restricted to certain guidelines, regs, and everything else that we have to follow and comply to. Last night I was watching Chicago Med, and so there was a mentor. The doctor had this mentor, and she was failing. But the one thing, the most powerful thing she taught me, he was sharing, is always treat the patient and not the disease. So based on that, he was able to make his decisions on her care, which was to be able to unplug and let her go. Always treat the person. And sometimes I think we forget that, to treat the person, because they've got to fit in this little ticky box. Yes, yes, no, and whatever else goes with that, eh? We forget that we're dealing with a person's life. So everything about Part 10 to me addresses, everything to me says we should be, I know you're not the ministry here, but maybe you could pass the word on, is, realign so that you could reinvest in the families where the journey begins, so that we can provide and support different outcomes. Because as I mentioned this morning, we're raising another generation and another generation, and when will we see visible results? Maybe not in our time, but I have a granddaughter too, and I want to make sure that there's a good life for her if she ever ran into problems, that she would be protected and looked after. Of course, Grandma would step in. I got the biggest bass badge. I always say when I worked in child welfare in the community, and when I needed help, I would call the grandmother, and Grandma would come in before the CAS got there. And Grandma would take the kids so that when the CAS got there, there was no kids there. Lorraine kind of knows that because she was one of the workers that used to visit our communities. But just to be able to empower the family, to look after each other, take care of one another, so that we don't all become stats. You don't have all our data and the story. Let's work ourselves out of a job 25 years from now and be able to replenish what that family looked like. So I know that it's getting late. I see 000 here. I think my clock stopped. Can you reset it? Yeah. So anyways, in my closing, I'll do my closing in my language again. As a speaker, we're taught that when you offer prayers, to the Creator, we speak in our language so that they can understand us, because our ancestors spoke the language. So when I say my name and say the prayer, they'll say, oh, okay. Oh, yeah, we remember her. we'll answer her prayers. No, just kidding. Doesn't always happen. I've asked for a Lotto Max for a little while, numbers, and I'm still working. Yeah, no. You know, prayers are not about anything like that, but it's for guidance and direction. And help me. We call them, you know, help me in whatever I'm doing, to find the words that I need to share, to do the things that I need to do for my family, my, you know, extended family. Help me connect with my heart and not forget what life is all about. Right? That's the most important thing we can give anybody. So I'll do my prayer, and I just want to say Chimigwech, which means not just thank you, but a big thank you. To have had the pleasure of meeting some of you, and I wish you well, you know, in the work that you do. And maybe we'll cross paths again and get to spend some time. Who knows what tomorrow is going to bring us. But for today, we express our gratitude for a beautiful day, because we're here physically in this room, participating in some of the most important work that we are responsible for. So I'll do that, and I'll let you go. No, just kidding. I got a bit of a mischievous sense of humor to me too. It's my balance. You know, we do so much hard work, serious work, heavy lifting, heavy thinking, and so that humor comes up and it kind of gives you some balance again, and so that you're not too lopsided, eh? And always using your intellect and this beautiful heart that we all have. Habojo, Gshemnedo, Mishomsak, Nokmisak. When I say that, I'm giving thanks to the grandmothers and to the grandfathers. Kchimigwech, Gibishai, thank you for being with us today. We not moshyang genina, weina, we nagdenmang, to help us think with a good mind. We not weina, we moshchiging, to be able to feel with our heart. We've zindadying, we not mudding, to listen to one another and to be able to help each other. Objectivity tendawat manda enangshing. The work that we do is so big, it's so important. Midash mandakashkitmine, and when we could do all of these things, mi mandam nakshkezian ishnakadek. This is what we call good work and progress. So we thank the grandmothers and the grandfathers from the 4 directions for coming to be with us today. Kchimiwech mishomsak, nokmisak, kibishaik nangwa. Pamapi, mino, kagabosen migo, wibishaik. Thank you for coming, and we will ask you to help guide us again down the road. Miigwech. So then I say thank you to the 4 directions. Miigwech, miigwech, miigwech. All right, so thank you, and have a good day.
And with that, I draw the session to a close. Thanks to everyone who was on the stage, behind the scenes, and thanks to everyone here in the room and online. Terrific day, and keep an eye out for materials and the evaluation form. Wish you the best, and have a great long weekend coming up. Take care, folks. Bye-bye.
education, but I can see right through a powdered face on a painted fool. Let me slip through. Why you tryna hold me back? I'm just tryna move up front, little more this, little less of that. Let me come through. I'm tired of being in the back. I'm just tryna move up front, little more this, little less of that, yeah. They tell me I was born to lose, but I made a good thing out of bad news. I don't worry about people in my face. I hit them with the style and grace, and watch the ankles break. Whoa, whoa. I know you wish I would fade away, but I got more to say. Lord, they pray. Ow! Let me slip through. Why you tryna hold me back? I'm just tryna move up front, little more this, little less of that. Let me come through. I'm tired of being in the back. I'm just tryna move up front, little more this, little less of that, yeah. They tell me I was born to lose, but I made a good thing out of bad news. All day
Part